It's on 12, 10th of January, 10th of December.
2 weeks time.
Why?
Some difficulty from senior counsel.
So we'll see first. Let it come on 10th. We'll see.
Your Lordship, 44 to 53 is the series matter. So all these matters may be taken together.
44.
44 to 53.
That's right. It will come on 10th.
Oh, yeah.
10th of December.
There's an interim order.
Interim order passed earlier will continue.
Item number 20. And this can go is there, madam. Today she has some difficulty. May paper take up the matter tomorrow.
Item 20.
20 minutes.
Tomorrow.
Tomorrow.
Not tomorrow. It will be next week.
Monday.
Monday. Item 20 on Monday. Yes.
May I please, Your Lordship, item number 28 and 37. I have taken the consent. 37. Kindly the matter may be taken up on next week. Your Lordship.
Monday. 28,
Lordship,
29.
May I please, Lordship?
Yes.
The matter is about the acquisition of land. It was last posted on 18/11. On that day, the affidavit in opposition was not in record. Accordingly, direction was given to list after 1 week. It has not come up, so I am trying to list it on 18th of December. Lordship.
18th of December. All right, 18th.
May I please, Your Lordship? I think to mention item number 39 and 48.
39
and 40, 39 and 40. The similar 4 matters have been listed in the month of January. As per the order dated 29 of 11, 2024, passed by the Honorable Court. So these 2 matters may be taken along. I'm for the petitioner.
Okay.
In the meantime, we'll be filing our affidavit.
Listed on?
Date has not been fixed.
Maybe on 3rd of January.
3940 at the request of counsel made by the respondent for the respondent is in the month of January.
And the other arbitration, similar matter, arbitration petition number.
No, you make a mention
Okay.
before the court. By
Obliged.
getting a mention memo.
Lordship, there is another pair with the consent of the other side. I beg to mention item number 56. Lordship. I, on behalf of H. Gupta, CGC.
So I'm appearing for the petitioner. I'm
Yes,
appearing for the petitioner.
yes.
It may come up in the month of January.
All right, item 56 in the month of January.
Deeply obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 15 of this today's list to be withdrawn with the liberty to file a press.
Why?
Because some modifications are required, Lordship.
1515.
Only 15.
Item 15 at the, your Mr.
AK Henry, Lordship.
Mr. K.K. Henry, counsel for the petitioner on instructed submits that he'd like to withdraw the writ petition with the liberty to refile the same view of certain corrections which are in view of certain errors which is crept in due to oversight. Prayer made is allowed, writ petition stands dismissed or withdrawal with liberty.
Deeply obliged, Lord.
May I please? I beg to mention for listing new case.
Why? He'll come on his own. What is the problem? When did you file it?
File on 2nd of December. Lord.
He'll come next week.
Urgent matter.
He'll come next week. Yes.
May I please, Your Lordship? Well, I should beg to mention a listing of IA civil. We had filed an indictment IA, which is need to be called on listed on 13 or 9.
You have a mention memo.
Yes, Your Lordship.
Where is that mention memo? All right. Give it to the second court master. They'll give a date.
Sir.
Yes.
I pray for 2 matters for withdrawal, Your Lordship.
You want to list it
Yes, Lord.
Monday?
Sir.
Item 1.
May I please, Your Lordship? Lordship, the petitioner is one of the partner of a partnership firm. There is a dispute between the partners. The respondents are the other partners, and the partnership did contain an arbitration clause, Lordship. So,
Where is the partnership? Where is the
Lordship,
clause?
page 19,
19?
page 18, Lordship, clause 19.
Right. Heard Mr.
G.
Kandelia, counsel for the petitioner. Issue notice returnable 4 weeks. Steps on the respondent by registered post AD along with neutral courts. Based after returnable date.
Much obliged.
Three, go ahead. Yes,
My lord, the writ petition is pending and it is, my lord, ready for admission. And the interim order was passed for no construction of fourth and fifth floor. But they are still constructing, and we have third copy at page 24. And my lord, 24, and thereafter, my lord, earlier also in,
notice is issued in the writ petition.
my notice issued interim order and service is complete as regards admission. Office note says,
Who's for the respondent here?
I am for private respondent number 5.
Why are you constructing it?
Lordship,
In spite of the order?
Lordship, we have not constructed anything about the 4th and 5th floor as Ellis. Lordship, the report may be called from the official respondent. In the meantime, we will file our affidavit, Lordship.
Right. In view of the order dated 18/12/2023, passed in WPC 6944 of 2023, directing respondents 3 and 4 not to construct, not to proceed for construct, not to proceed with further construction in respect of the 4th and the 5th floor of the building in question. And in view of the statements, submissions made by the counsel to the petitioner that notwithstanding the orders passed by the court, the respondents have violated the directions contained and have proceeded for construction in the 4th and the 5th floor, a contempt petition is filed, being contempt petition number. This order you pass in the contempt petition is filed. So let the respondent GMC, who's representing, yes,
Lordship,
sir,
I am
right. Please give a report as to whether the constructions are being carried on or not.
Lordship, in the contempt, Lordship is issuing notice.
We'd like to have the report, then we'll decide whether to issue notice. Because the writ petition is pending otherwise.
Yes.
This is against the interim order.
In fact, we have communicated, but instruction is awaited.
Let the report be filed. Within how much time do you require? 1 week?
After vacation, immediately after vacation.
No, it's only a report of whether this order has been complied with or not. That's
Yeah.
all. We'll have to go and give a report to say whether they have carried on the directions of the court.
Next week, that's all.
Next week. Matter be listed on 16th,
Lord.
my lord, as regards
by
the,
which time the GMC authorities will file the report indicating whether any construction on the 4th and the 5th floor is being carried on by the respondents in spite of the order dated 18/12/2023 passed in WPC list on so and so date.
well, in the writ petition, the interim order was still today because still it should continue.
Then the writ petition you write in view of the order passed in a contempt petition, interim order shall stand extended till 16th of December.
Problem.
This case, my lord, the order you will find at page 7, my lord. Operative person at page 11, my lord. Due to violation of the honorable court's order, my lord.
Paragraph,
Paragraph, my lord, 13 paragraph may kindly be seen, my lord.
you have approached and filed a representation.
Yes, my lord. Yes, my lord.
Sir, so and so aggrieved, alleging willful disobedience of the directions contained in the order dated 7/6/2024 passed in WPC 110 of 2021. It's contempt petition, right? Issue notice returnable 4 weeks steps on respondent
Sole respondent.
responded by usual course registered post city. List after returnable date. वो क्या बोला था फाइल रेडी करके रखिए बुला दीजिए.
I think. My lord, in consequence to order dated 2011-24, some instruction was called for.
Yes.
Look, I have received an instruction, but this doesn't seem to be conclusive as regard the query that the court has made. They have said that the compensation amount hasn't been disbursed till now. And the circle officer, who is the competent authority, has been directed not to disburse till the next date of hearing of this case. Good read.
So we wanted you to have the instructions with regard to some representation.
That's what after going through this, I could find out that that is not conclusive.
You find out.
Yes.
Mr. S. Burwal and an advocate prays for further time. List the matter in January.
The interim order to continue.
20 January 20th January. Interim order passed earlier will continue to the next day.
Okay.
Mr. P.K. Roy for the petition.
On the last location, instruction has been called for.
Yes, any instructions?
No, lots of communication is done, but we are yet to have.
Mr. S. Burwal, an advocate, prays for further time. Complete his instructions. Let the matter be listed again. January 10th of January.
My presence may kindly be recorded for
Is VKC
3 and 6.
for respondents 3.
3 and 6.
Yes.
Also, presently the account is under the debit freeze because of this letter at page number 22.
22.
And we do not have any communications from the department concerned for unfreezing of the account.
No, under what provision you have frozen the account?
Only on the basis of this letter, Your Lordship.
What is the procedure for that? Somebody writes a letter, you freeze the account.
Your Lordship, generally what was happened that when the communication is being made by the statutory department, we have to follow this, Your Lordship.
No, wait, under what? You have to follow it is all right, but he is your customer. He has opened a bank account.
Yes, Your Lordship.
You have a business transaction with him. You're not doing charity for him.
Your Lordship, there is some RBI guidelines.
So where is the guideline?
Your Lordship, kindly allow me sometime, I will bring it.
My lord, may I play, my lord, in this case, my lord, notice may be issued. In the meantime, my lord, since May, my lord, I am not permitting to withdraw my pension, my lord. Only to the tune of my pension, I may be allowed.
We wanted to see the guidelines and instructions, therefore we fix the matter today. You want a notice, we'll issue notice. Heard? Mr. Learned Counsel appearing for the petitioner, as well as Mr. Sharma appearing for the client. Issue notice, return and 3 weeks. Since Mr. Sharma appears for the respondent 6 and 7.
Yes, Your Lord.
Notices are waived. Mr. S. Burwa appears for respondent number 2, 5. 5, 6, 7. Notices are waived, extra copy to be published. Steps on who is appearing for union?
Union.
Steps on respondent number 1, 3 and 4 by registered post city to be taken by the petitioner within 1 week from today. Let the matter be listed on 22nd January.
In the meantime, my lord, I may be allowed only my interim period only
On
limited.
what basis?
Because
On
it
what
is
basis?
my lord, the
You
account
show
is
us- you
not
show us-
wholly freeze, my lord. It is debit free.
We are trying to understand under what provisions the accounts have been freezed,
Yes.
whether the provisions have been
Yes,
followed or
that
not.
is a matter of adjudication, my lord. Because
Therefore-
since May, my lord, I am without.
So the adjudication is whether you should be allowed to withdraw money from their account.
I am not praying for whole withdrawal, my lord.
Ah.
Only to the tune of my pension, my lord. That much, my lord. Because without pension,
Unless you show us. Therefore, we did not issue notice. We wanted the instructions to find out.
then, my lord, it may be.
We have already issued notice. Let it come in January. Wait for whatever
Because
instructions
since
will come.
May, my lord, I am without pension, my lord. Only my prayer is, my lord, only to the tune of my pension money, I may be allowed to withdraw my pension.
Show us some authority, you show us some rules, regulations, then it is permissible to do so.
They can, my lord. Your lordship, my lord, said the ending letter that they have said only 81,000, my lord, only 81,000. I am not.
That you go and represent before the bank authorities. Tell
And
them,
that 80, as regard that 81,000, I have informed the local police. And local police investigated about that 81,000, my lord. My prayer is not to allow me as a whole, my lord, whole operation. Only my pension amount I may be allowed, my lord. That's that much, my lord.
we'll examine on the next day.
Then, my lord, may observe the interim order, interim prayer.
Interim prayer, if any, will be continued on the next return of date. Yes?
Will be considered on the net.
Will be considered on the next return of date.
My
Yes.
I am obliged.
Item number.
Item 8.
अरे पुलाव तो भाई आप क्या हो गया कंफ्यूजन क्यों हो गया?
Exactly, Lord.
Yes.
Lord, the matter pertains to 2% forest royalty. The petitioner, my lord, applied.
Some matters were pending.
Yes.
Some matter
Already
even when
disposed of.
lordship comes to the PR, he wants to challenge the gazette notification, Annexer E. But gazette notification, he has to go to the division bench. In fact, my lord,
No.
PR is for Annexer E. He should have challenged Annexer F, which has already been passed.
After my lord filing this petition, I came to know that this issue has already been decided.
Yeah.
Then-
But his PR is Annexer E.
Then what remains?
Covered
Nothing.
case, my
Covered
lord.
case. Now it's a covered
I
case.
am praying for similar care.
All right.
Only forest royalty.
Only this similar has already been passed.
Give us this order. Is it available here?
No.
Is the
no,
order available?
No. No.
After filing my writ petition, I came to learn.
What is decided here?
Uh,
What is decided here?
That
My lord,
notification, that letter, my lord, Annexer F, my lord, that has been
Communication.
communication for taking 2% royalty that has been set aside. Page number 40.
040. Yes, 40.
This is letter dated 2nd March 2023.
40.
40.
Type copy is 40. Originally 41.
Communication dated 2/3/2023.
So if this is already set aside,
Already set aside.
then what more is required to be done?
My lord, that is, they are, my lord, orally instructed us to deposit the forest royalty. But similar order may be called,
How can there be a similar order?
similar type.
This letter,
Otherwise, my lord, he has to pay.
This letter has already been set aside.
Yes, my
Can it be again set aside? Already set aside.
lord, dispose of my petition in terms of this. Otherwise, my they are demanding mine,
All right.
or my building permission is not given.
Heard Mr. S.A. Ahmed, learned counsel for the petitioner, Mr. S. Bora,
I am
Hearing-
appearing 4, 7 and 8.
appearing for
4, 7 and 8.
4, 7, and 8. 4, 7, 8.
I am appearing for respondent number 2.
You're Mr.
P. Das.
P. Das.
P. Das.
P. Das. It is for respondent number 2. 1 and 2. Commissioner and Secretary, Forest.
1 and 2, he will appear.
1 and 2. Who's for 3?
I appear for 3, 5 and 6.
Mr. S. Bora. So, Government Advocate appears for 3, 5, and 6. Mr. S. Bora appears for 4,
4, 7 and 8.
7, and 8. The petitioner is before this court, putting to challenge the communication dated
2/3/2023. Yes, but
you are putting to challenge Annexure E.
Annexure is, that's the review, it's
Now
a
I am-
notification. That's it.
now, my lord, I am not pressing.
Not present. Approach this court, putting to challenge the communication. The notification dated 7/10/2021, whereby the Assam minor concession rules were amended. Stop.
That cannot be challenged, my lord. That's
However,
the-
and the counsel for the petitioner has submitted to this court that he has instruction that the challenge made in the petition, so far as the notification dated 7/10/2021, is not pressed. Instead, he is aggrieved by the communication dated 2nd of March 2023. Communication number so and so, page number 40, dated 2nd of March 2023, within bracket annexure F, whereby the Department of Mines and Minerals has informed the Department of Housing and Urban Development, Urban Affairs Department, that the notification dated 7/10/2021 will be applicable for realization of forest royalties in both government departments as well as urban local bodies for both government and private agencies until further order. It is the submission of the council to the petitioner that although the writ petition was initially directed putting to challenge the notification dated 7/10/2021, within bracket annexure E, subsequently he has been informed that the coordinate bench has already passed an order. Notification was not interfered with.
Notification is not negative. In fact, I think it's a topic of, you should have challenged the next of 5, next F.
That the communication dated 2/3/2023 issued by the Joint Secretary, Department of Mines and Minerals, Government of Assam, within bracket annexure F, was interfered with and set aside by the judgment and order dated 24/9/2024, passed in WPC 4085 of 2020. Stop. He therefore submits that similar order be issued by this court. So, Mr. S. Bora, learned counsel representing the, what is that? Mines and minerals.
No, I am not representing, madam.
You are
Government is representing, I am waiting on 4, 7 and 8.
representing the respondents 4, 7, and 8 submits that if the petitioner wishes, if the petitioner has put to challenge the notification dated 7/10/2021 within bracket annexure E, then the matter ought to be placed before the division bench at the registry. However, if he has abandoned the challenge and has instead challenged the notification, communication number so and so dated 2nd of March 2023 within bracket annexure F, then the coordinate bench by judgment and order dated so and so passing WPT so and so has already interfered with the same. Having heard learned counsel for the party, it is seen that by judgment and order dated so and so passing WPC so and so, the notification dated so and so has already been interfered with. So, therefore, no further direction is necessary to be issued interfering with the said notification as prayed for by the learned counsel to the petitioner. Stop. Since the petitioner has abandoned his original prayer, putting to challenge the notification dated 7/10. 7/10/2021 in bracket annexure E, and the communication number so and so dated 2nd of March 2023 within bracket annexure F having been already set aside by judgment and order dated so and so passed in WPC so and so. No further order is called for in the present writ petition. Stop. However, taking into consideration the submission of the learned counsel to the petitioner that the notwithstanding the interference of the communication number so and so dated 2nd of March 2023, page number 40, by the court, by this court, by the judgment and order dated so and so passed in WPC, the Mines and Minerals departments have been verbally insisting, have verbally demanding the payment of forest royalty from the petitioner. Stop. Petitioner, comma. This writ petition is disposed of with the direction that in view of the communication numbers so and so dated so and so passed, having been set aside by judgment dated so and so, passed in WPC so and so by this court, no further demand can be made from the petitioner on the basis of the communication number so and so dated 2nd March 2023 with the bracket annexure F, enclosed to the writ petition. Any such demand, if made, is contrary to the judgment and order passed by this court. Ordered accordingly, writ petition disposed of.
Lordships, may I just pray before your Lordships? If inadvertently, my signature was not taken on the Vakalatnama. With your Lordship's due permission, I may be allowed to make.
Your?
Inadvertently, my signature was not taken on the Vakalatnama, your Lordships. My juniors forgot to take it. With your Lordship's due permission, if I may be allowed to make submissions, and I'll rectify the mistake as quickly as possible.
Do it in the presence of the court.
Yeah, deeply obliged.
Yes.
Lordship, the matter before your Lordships with regard to 2 inmates who are incarcerated in the Moregaon District Jail, and they have been convicted under the NDPS Act and undergoing a sentence. The limited prayer before your Lordships is that the inmates are, as per law, entitled to be shifted to their home state if there is a overcrowding in the district jail where they are in housed. Right now, the district jail at Moregaon has a capacity of 256, whereas the inmates actually over there are more than 335. So therefore, and considering the fact that the petitioner number 1 is an HIV positive person, plus the conflict which has been going on in Manipur, they have lost contact with their family members, Your Lordship. So the limited prayer before Your Lordships is that they should be transferred to the district jails in Manipur. That is the limited prayer. At this stage, I'm only asking for a notice of motion to be issued. Although similar matters have been moved.
Transfer will have to be agreed to by the.
Yes, Your Lord, by both the
authorities
states.
concerned.
Therefore, my only prayer at this stage is for a notice of motion to be issued. And
You'll have to perhaps array the NDPS authorities also.
I have, Your Lordships.
You have?
The what authority, Your Lordships?
Who they are convicted under NDPS.
Yes, Your Lordship.
By which authority?
By the trial court, by the special judge, Your Lordships.
Oh, this is
Special
pursuant
judge,
to a,
Moregaon.
this is pursuant to a judgment.
Yes, Your Lordships.
Okay.
I have annexed the judgment at annexure 1, page 20.
All right. Heard MSR S. Chaudhary, heard counsel. Hearing for the petitioner. This writ petition is filed by the petitioners who are presently undergoing a sentence pursuant to eviction by which court?
Sessions judge, special judge, Moregaon, Your Lordships. At page 20.
Special Judge Moregaon.
Sessions judge comes special judge, Your Lordship. Moregaon, Assam. Under section 22C and 29 of the NDPS Act.
No, the court is of the special judge.
Yes.
The presiding officer is a session judge.
Yes. It was written in the judgment. I just read it out.
Court of special judge by the judgment dated 26/5/2022 and 3/05/2022 in NDPS case number 03/2020. So,
You asked for it.
by the said judgment and order, the petitioners, there were three convicts.
Yes, Your Lordship. There were 3, but before Your Lordship, Suresh Singh is already is not before Your Lordships. Petition number 2 and 3 of the judgment are before Your Lordships in this writ petition.
Who is here? Suresh Singh,
Suresh Singh is not here, Your Lordships.
not here.
L. Sanameti and Inocha Singh are the 2 persons who are before Your Lordships.
All the 3 accused, including the present petitioners, were sentenced to undergo rigorous imprisonment for 14 years and also pay a fine of ₹1 lakh. And in default, to undergo simple imprisonment for another 3 years. So, out of the 3 accused, 2 of the accused, namely L. Sana Maiki and L. Inaocha Singh, are before this court as petitioners. So, petitioner 1, it is submitted that petitioner number 1 is also an HIV patient and is in need of specific medical care treatment. So, the petitioners are before this court praying for a direction.
Lordships, section 80 of the Assam Prisons Act 2013, as well as rules for superintendence and management of jails in Assam, rule 504D. I have quoted the rule in my writ petition.
Page number?
Lordships will find it at page number 12, Your Lordships. It starts at 11 and 504D is quoted at 12. Paragraph 9.
Prays for a direction to transfer the petitioners to the district jail in Imphal. Where do you want it? Imphal.
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 Yes, Your Lordship. Imphal.
As
You're
their
asking for Imphal, right?
their permanent residence of Imphal.
Yes, Your Lordship.
As their permanent residence of Imphal in the state of Manipur. Learned counsel for the petitioner has referred to the provisions of the Assam Prisons Act 2013 as well as the Transfer of Prisoners Act 1950 to submit that there are provisions to transfer the prisoners undergoing sentences in the event of overcrowding in the jails. So is submitted to the Moregaon district jail at present houses about what is the
The lordship, the capacity of the jail is 252.
Where do you?
I
where
have
have you
stated in paragraph 9 of my petition, your lordships.
estimated
page 12.
That
Registered
the total number
capacity.
of inmates incarcerated in the district jail of Morrigaon at present is 337
7.
as
Whereas
against the registered capacity of 252.
Lordship.
And therefore, there is an overcrowding in the jail population by about 131.34%. So, under such circumstances, the present petition has been filed. Mr. Borwa, you appear?
Yes,
Mr. Rez,
I appear for
respond.
1, 2 and 4.
5. 1, 2 and 5.
4.
मणिपुर कैसे हो सकता है नहीं 1.5
Oh, sorry. No. 4 is a superintendent of jail Morrigaon.
That is number 5, yes. In your petition, it is not.
Oh,
been correct.
there is a reputation of 3.
Yes. 1, 4 and 5.
1, 4 and 5.
Therefore, notices are waived. Extra copies will be furnished within a period of 1 week from today. Steps on respondent number
3 and 4, your lordships, by registered court.
by registered court, as well as usual courts. Correct. Let the matter be listed again after the returnable date, and let the respondents bring on record, complete their instructions and file necessary affidavit if so advised at the time.
I can pray with your pleasure. Lordship, may I just be allowed to sign on the allotment
Yes.
in the presence of the court master?
कोई वकालतनामा साइन करेगा
I'm deeply obliged to you, lordship.
May I
Yes,
please
yes.
appeal? In this case, your lordship, we have filed this writ petition under Article 227 of this Constitution of India, your lordship, for directing the respondent authorities to consider the case of the petitioner by directing the bank authority to allow the petitioner for withdraw the.
What was the order of the court?
Yes, lordship. Rejection order or judgment, your lordship?
No, judgment.
Judgment at page 19, your lordship. Annexer. Sorry, your lordship. At page 12, your lordship. 12 onward. And the order, your lordship, at page 17. Paragraph number 13, your lordship.
So how much amount did you receive?
Only total awarded amount was 7,82,300, your lordship. Out of total, your lordship, 6 lakh already has been fixed for deposit in the bank of Assam Gramin Bakers Bank, your lordship. And thereafter, petitioner filed application for withdraw the pre-matured
No, you
amount.
received some amount.
Yes, lordship.
Balance amount along with interest. What is the
Yes.
amount you received?
About your lordship, around 3 lakhs, your lordship.
Now you want more money.
Yes, lord.
Why?
We have stated my in my writ petition paragraph number 6, 7, and 8, your lordship. Due to this accident, your lordship, petitioner has been become in permanent disability of 60%, your lordship, of his leg, right, your leg, your lordship. We have annexed the disability certificate also.
So the court has directed release of 1,50,000.
Yes, lordship.
Huh.
And thereafter, we have filed another application for withdraw the entire premises amount, your lordship.
Why?
Because we have stated in paragraph number 6, 7, 8, your lordship, because the petitioner want to open a grocery shop and he has to remove his plate. This plate has been fixed in his leg, your lordship, through operation, your lordship. There
So
will be.
then the entire award, the order of the MSCT will be it amounts to a review of that order.
Because your lordship, the award was passed in the year of 2018, your lordship. Accident took place in the year of 2015.
We don't find any infirmity in the order.
Lordship, due to this disability of 60% disability
You had
by the
already explained the first application. You mentioned you wanted to open a grocery shop and you wanted 1,50,000.
lordship, we have
Court
a
had
prayer
granted
for
that
3 lakhs, but honorable court, learned court below the
They
release
granted you 1,50,000.
150, yes, lordship. And petitioner has already taken money from the other person through promissory note, your lordship, 2 lakhs. It is not fulfilled for his requirement, your lordship. And due to this disability, your lordship, he has not earned like prior to the accident, your lordship.
You have not even made the bank a party.
No, lordship.
Then?
Because if Lanet Court will
You are seeking an order against which authority? MSCT.
member, your lordship. Member,
MSCT.
yes, lordship. Member will direct, then court will be, bank will be released.
We dismiss with cost or you want to withdraw it? We'll give you one more opportunity. You think over it. It is one thing to appear in court and argue. It is one thing to know the law properly, procedures, and then submit before the court. You come back on Monday. Think about it.
Lordship. So,
List on Monday. The request of counsel for the petitioner.
And regarding that, my lord, DRC 1, my lord, under section 73.
That we have already disposed of.
Yes, my lord, let it be on Thursday. At least for inspection, I will have whether the SOCOS was actually issued or not prior to issuing the DRC 1, lord. Thursday. On Thursday, my lord.
What are you challenging here?
My lord, that order, my lord, and DRC 01, both.
SOCOS was not issued.
Not
That is their claim.
Same issue.
List on. But if it is because the what is issued? The summary.
Summary.
Yes, they used to issue a my lord, DRC 1 notice, summary of the SOCOS and an attachment. Whereas my lord, a specific SOCOS is required along with this DRC 1.
So if it is, it's evident from the order that it is not issued.
One court instruction on Wednesday at least.
All right.
On motion,
on. We'll have it on 12. List on 12 with the request of learned standing counsel GST of details instructions. As to whether SOCOS notice was issued along with the DRC. DRC 1 form.
Item 12 is similar, man.
Item 12, same order.
Deeply obliged.
Item 13.
Please, your lordship.
Yes.
This petition has been prepared by this petitioner. These petitioners are all senior citizens, and they are residing in a plot of land measuring around 3 quaternions, 19 lesas, which is covered under the tag number 630 and 1033, covered by the patta number 223 under the Beltola Moja. So till this point of time, everything is good. Now, what has happened is that this petition has been prepared by because of the inaction of the police department while entertaining a complaint.
Why don't you apply under the BNSS? There are provisions for remedies available for not registering a fire.
My lord, so this is the reason why they had come to this honorable court, so that some action should be taken by the police as per the provisions of the law. And till that point of
there are provisions there. You have to explain why you have not approached there. Not that we are powerless, but there is a provision under the Act.
Yes, my lord.
So why have you not approached?
Alternative remedies there, my lord. Totally, it is agreeable. Only the fact is that now, since these are all aged old petitioners, my lord, and this plot of land has been acquired by them through inheritance and through mutual consent by the
Right, heard Mr. W.R.
Medi.
And Mr. Sharma Burwa. Please get your instructions why FIRs are not registered.
At least the
There is
preliminary inquiry
there is a website, as far as I am informed, where you can file online FIR. Physical FIRs are not registered. Why? In spite of repeated judgments by the apex court, high court. Any FIR file has to be registered. Get your instruction. Why FIR is, if at all filed, why not registered?
My lord, if permitted, have also annexed one similar judgment that has been passed by this honorable court.
No,
Annexed-
let us
annexed-
first get the instructions and then we'll.
Interim may be considered that no interference with the legal
Let
possession
us
of,
find out what orders.
because they're all age-old petitioners and they are staying at their own plot of land. And these private respondents, they are also family relatives, man. Now, what has happened is that in collusion with these hired goons and land mafia, it seems as if now these people, they have gone through the
No, you
approach-
get instructions, we'll take it up on Monday. Just find out why FIR is not registered.
Monday.
Or at 2 p.m.
Yes, 2 p.m. At 2 also.
This is only in Guwahati, whether FIR has been registered or not.
This court will stay. It's lots of, ultimately we have to scan the entire copy. So can it be on Monday?
All right, Monday. Mr. S. Borwa's government advocate will obtain instructions as to whether the FIR stated to have been filed by the petitioners have been registered and investigations thereunder have been initiated by the investigating authority. Placed on Monday.
Obliged.
You give him an extra copy today.
Yes, ma'am. Obliged. This is relating to village Procedural Patna matter. Procedural Patna, they already evicted.
They are evicted.
Evicted.
So,
A similar matter takes on 16, my lord.
if you are evicted, why have you filed the writ petition?
Because my lord, without any serving any notice, we pray for
Okay.
rehabilitation.
Heard Mr. J. Ahmed, learned counsel for the petition.
They execute a similar order.
S. Borwa for
For 2, 3, 4 and 5.
respondents. 2,
2,
3,
3, 4 and 5.
2, 3, 4 and 5. MLPR Monto for respondent number
1 month.
Case 28. 281, similar order.
Since the learned counsels have already entered appearances for the respondents, notices are waived, extra copies be furnished. And matter be listed on
16,
16, 12.
16/12.
12.
And it is submitted that similar writ petitions having similar prayers are also listed on the same day. List
Hello,
on
sir.
16/12.
Some observation, my lord.
What?
They will file a video and indicated.
Well,
Page 281, my lord.
You get instructions, we'll see what.
Page 281, my lord.
Affidavit in fact filed.
they have
We-
already
Let it
filed
come on
that.
16. You are already evicted.
Yes, my
Yes,
lord.
yes, there is some observation making them, they filed a video indicating the.
By
whether-
16th.
Oh, yes. Now, in that case, earlier case.
Earlier case is not here.
Yes, yes.
Well, only page 281,
Only one
281.
wants to pass an order in a matter which is not yours.
Only page 281 you lost file is in there. Page 281.
That are filed. We have already filed, my lord.
You have filed in that matter.
No.
No, that another one matter they.
It speaks on 16, my lord.
So let it come, we'll see on 16th. We can't give you an interim order today.
No, I am not in the order, but
Then,
there is a order passed by this noble court that on not before reasonable day, the respondents are directed to bring on record their stand by filing a video.
Filed.
how is
In
the file
addition
filed?
to that, the respondent
No,
has
we can-
also
we can
also
give that-
indicate in the affidavit as to whether where those petitions can be rehabilitated, taking into account that the petitions have already been
That
disposed.
observation we can give if you agree to have the matter listed on 20 January. We'll have it on 20 January,
Well,
or you want it on 16.
27 is not no problem, but if that case is decided, it will be covered.
We are asking you whether 16 December or 20 January.
16 days.
16. So we'll see on 16. Yeah, okay. Yes, item 16.
This matter, my lord, not giving the NOC for construction, my lord. Petitioner is the, my lord, builder. Is the attorney holder, original landholder. Original owner is the owner of 3 bigger land, my lord.
NOC to be granted by whom?
The municipal board, my lord. Keshpur municipal board. They have not granted, my lord. They have not denied the because of the they stated that.
There is an appellate forum under the Act for orders against The municipal authority, appellate authority is there.
Then, my lord. Leave may be granted, my lord.
Mr. Borua
Yes, so, yeah, my lord.
as Soikia and counsel for the petitioner. Appears for the petitioner. Submits that the petitioners are aggrieved by non-issuance of NOC for construction of their carry out construction as trade port and no reasons. Has it been rejected?
Yes, my lord, rejected. My
Where
lord.
is that order?
Yes, my lord, page 73, my lord. Annexure L, my lord. The communication written, my lord, by 9/7/2024, my lord. In the last order.
Submits that the same has been rejected by communication dated 9/7/2024 within bracket annexure L. Aggrieved, being aggrieved, he is passed. He has approached his court. Let the matter be listed on 24th of January. Mr. S. Borua appears for respondent number 2.
2 and 3.
2 and 3. MSPR Monto for respondent number 1. But who is for Tezpur Municipal? Is there any standing counsel?
No.
We have to issue notice.
Then you issue notice. Issue notice returnable 4 weeks. MSPR Monto for 1. S. Borua for 2 and 3. Steps on respondent number 4. By usual court registered post.
My
Is
my-
after.
my name is on my lord. I have signed a color number, my name.
Mr. We have recorded your name as Soikia.
My lord, in the course list, my lord. Otherwise, I will miss. My lord.
Name of the council, Mr. S. Soikia, be reflected in the course list by the registry.
Always.
This petition is against the non-payment of direct compensation, Lordship. No, petitioner here in order, Lordship, legal heir of the original awardee, Lordship. So now
So where is your application before the authorities?
my
Page
page
27,
27, Lordship. Annexure 5,
27.
Lordship.
27.
Lordship.
This is to be before the Kala. It is the, who is to decide this?
Yes, sir.
Competent authority.
Yes, sir.
So it has been referred to arbitration.
Yes.
Arbitration award is also granted.
That has been decided, Lord. And now the revised rate has been distributed by the office of the district commissioner, Lord. These persons have been left out because they are a legal heir of the original awardee, Lord.
This letter, this communication is before whom? Respondent number?
Respondent number 2, Lord.
2.
District commissioner.
Okay. When was it filed?
If date could not be given by the Lordship.
Page 22, Lordship. They filed some application before this, Lordship.
No date is there.
Page 23, date 1911, Lordship.
So you are asking, you are aggrieved by non-disposal of the representation.
Lordship. May I submit one thing, Lordship? In addition to this, Lordship, I will submit, Lordship, another representation, detailed representation, Lordship. Because all the petitioners have joined together, Lordship, and filed this petition.
Heard the learned counsel for the part petitioner, Mr. N. Goswami.
Two and three, Lord.
Respondent 2 and 3. Who's for National Highway? Mr. C. Bora is for National Highway. This writ petition is directed by the petitioners. Claim before this court is that their application that the direct compensation which was reassessed and could not be dispersed to the original owners have not yet been dispersed by the respondent authorities. Stop. The present petitioners are legal heirs of the original owners and pursuant to the arbitral award dated 1/7/2017, the revised Zirat compensation was required to be released to the present petitioners in their capacity as legal heirs of the original owner. Stop. In spite of applications filed before the competent authority, namely the respondent number 2, no steps have been taken for release of the revised Zirat compensation. Stop. Submitted that other similarly situated persons who had whose cases have been reconsidered for revised Zirat compensation have already been released. Stop. However, the cases of the petitioners have not been considered, and in spite of applications filed, no orders have been passed by the respondent authority. Being agreed, present with petition is filed. Considering the limited prayer made by the petitioners and considering the application stated to have been submitted before the Deputy Commissioner Hailakandi, this court is of the view that the matter need not be kept pending for instructions from the respondent authorities. So the court is of the view that the matter can be disposed of with the direction to the Deputy Commissioner Hailakandi to look into the grievances of the petitioners and if they are entitled to the revised Zirat compensation, the same should be released to them without any further delay. Stop. General counsel for the respondent also does not object to such an order proposed to be passed by the court. So, under such circumstances, the writ petition stands disposed of, directing the Deputy Commissioner Hailakandi to consider the prayers of the petitioner, the basis of the representation stated to have been filed, and thereafter taking into consideration the particulars necessary, or specific orders be passed in respect of each of the petitioners if they are found to be entitled to receive the revised Zirat compensation in terms of the arbitration award dated 1/7/2017. So, any further particulars that may be necessary for the Deputy Commissioner pass orders disposing of the representation may be called for from the petitioners. Stop. Let this exercise be carried out within a period of 60 days from the date of receipt of a certified copy of this order to be furnished by the petitioner. Writ petition therefore disposed of, but the motion states without difference.
Worship, this is with regard to an order passed by the circle officer, which is dated 11 of annexure 9, your lordship, 11/9/24. Now, your lordship has already taken cognizance of this particular case in a contempt petition, which I have argued before your lordship, because the order was passed by this honorable court in an earlier litigation, whereby some directions had been prescribed by following which the circle officer was directed to dispose of two boundary cases. One was 13 and another one was 64. However, he has proceeded only with regard to 13 of 19, and against which your lordship on 2nd of December had passed an order in the contempt case which we had initiated, bearing contempt case number 552 of 24. However, I could not place this judgment today, your lordship, because the order is yet to be uploaded in the system, your lordship. So the fact I will take your lordship now to the impugned, the order which was passed is at Annexure 8, page 59, by which the directions have been given by this honorable court. Your lordship will kindly come to page 62. The operative portions are there from para 6 onward. If I may read out, your lordship, para 6 of that earlier WPC. The
Yes.
learned counsel such and such appearing on the respondent submits that the copy of the application file leading to registration on boundary case number 61 of 19 and boundary case number 13 of 22 shall be handed over to the learned counsel of the petitioner within 2 weeks, 2 working days from today. Thereafter, the writ petitioner would be at liberty to file a fresh objection in both the boundary cases within a period of 15 days from the date of receipt of the copies of the application.
We had passed an order earlier.
Yes, that order is
contempt
in a
matter.
contempt case, your lordship, but
Contempt
the
matter.
contempt case order is yet to be uploaded in the system, so I'm not able to place that.
It should be uploaded. We have a copy from the system only.
Uh,
Anyway,
From the system, yes, today also I checked up, your lordship.
this is from the system. I don't know. The copy available is from the system only.
This is an earlier order of, but yes, your lordship's order was passed
It is
on
on-
2nd of,
Ah,
2nd of
This is the
December.
order.
But on the system, it is not that he has informed me.
All right. ये क्यों नहीं आ रहा है देखिए ये तो निकाला है ना इसमें उनके लिए नहीं आ रहा है हमारे लिए आ रहा है देख लीजिए
So I have not been able to get it in the.
we'll give it to you just now. No, we want
that may
to
be-
understand that there was some notice issued for proceeding in boundary case number 13.
Yes.
And the date fixed was 6/12. That is today.
Today.
And we directed that it shall proceed strictly in accordance with the directions contained in the order 7/8.
Yes.
Now, here you are asking for,
Because the proceeding, we need to stay, because this is the second occasion in the contempt which we had brought your
but
lordship.
here you are asking for a direction not to proceed.
We are not to proceed.
The direction has already been issued.
This was in the contempt case, your lordship. But
Maybe some direction is already issued.
it can be taken together, your lordship, with regard to that, because contempt would not be, maybe your lordship has.
Whatever it may be, but there is an order where we say that you should proceed after serving copies.
Yes.
And in the writ petition, you are praying for an order not to proceed.
Not to.
If we pass any order not to proceed, it will be contrary to the earlier order passed.
No, that is true, your lordship. So let it be.
We'll issue notice at this stage.
Yes, yes. Hello.
Heard. You can have a look at this copy.
And your lordship, both the matters may kindly be taken.
Both the matters means the contempt petition.
Yes, your lordship.
Heard. Mr. A. Biswas, counsel to petitioner, and MS G. Hazarika for respondent number 1, Mr. N. Goswami for 2, 3 steps on respondent number 4 by registered post AD as well as usual courts. The writ petition is directed for setting aside and quashing the impugned notice dated 11/9/2024. And for a further direction to the respondent number 3 to comply with the directions passed earlier by this court by the order dated 7/8/2024, passed in WPC 2097/2022. Considering the issues involved here, that notice issue returnable 4 weeks. the since respective councils represent respondents subsequently, notices are waived. However, extra copies be furnished within a period of 1 week from today. Let the matter be listed in January,
Yes, Your Lord.
22nd of January,
Hi, Your Lord.
along with. No, let the contempt petition come, then you can fix it together.
And both the matters may be taken up, Your Lord.
No. We have already passed an order in the contempt, which is not before the court today. So if you want, you can make a mention, or
Yes.
as and when the matter comes up, you make a prayer.
I'll make a mention. Hi, Your Lord.
Yes.
At page 19, my lord, by this allotment order, my lord, a plot of land, my lord, a vita named as Community Bazaar Vita was allotted to the petitioner.
Who are you? Who are you?
I am the NGO, my lord, secretary of the NGO, my lord.
It's a registered
A
NGO.
registered NGO, my lord. Annexure 1 is the.
Then you are
Well,
aggrieved
now-
by?
Madam?
You are aggrieved by which order?
My lord, there is no order, my lord. Now, my lord, the municipal board, my lord, started the art filling of the adjacent area and also the our allotted area, my lord, with a view to my lord, allot the same, my lord, to other person.
Have you been allotted any land?
I have been allotted, my lord.
Your land is being now sought to be filled up with art.
Yes,
Where have you stated that?
I have stated.
By which order of the municipal board?
There is no order, my lord.
Huh.
There is no order, my lord.
Show us how you have been allotted the land.
My lord, page 19, my lord.
19.
Even they are not accepting our tax, my lord, because the allotment was for the public.
Ah.
My lord, page 19.
Yes.
As per resolution number 3 adopted in the board meeting of Daboka Town Committee, my lord, held on so the community hall with land measuring 35 into 110 feet is allotted in the name of the People's Development Forum, my lord, with the following terms and conditions. For the date of issue of the order will be Vita whole name Community Bazaar Vita line with measurement across so the Daboka Town.
Now is there a town committee or municipal?
It is now municipal board.
Then
My lord, as on the basis of the population, it has been renamed as the board, my. Annexure 5, the order by which it has to become a board. Page 22, at scale number 61, Daboka Town Committee, Daboka Municipal, it has been renamed.
so you file a representation before the municipal board. Have you approached the municipal board?
Yes, of course, I have not took the receipt copy, my lord. I approached, my lord. Actually, I approached for renovation also, I have stated, my lord, in my petition, my lord. Therefore, they are.
Where have you, by what, by application, representation, you must have filed something? No.
I have filed, my lord, that I have not.
Bring it on record. You bring it on record.
That was not kept on our hand, my lord.
Where have you stated in your petition?
My lord, at
Where have you stated that you have approached?
my lord.
We'll close this petition, we'll give you liberty to approach.
But my lord, paragraph 7, my lord. paragraph 7, my lord. The fact remains as though that in personal section 7, converting renaming to town committee, my lord. Then, my lord, it is stated that even after the conversion and rename, the office bearer of the petitioner on many occasions visited the office of the Doboka Municipal Board, praying to allow the petitioner to clear all the toll and taxes in respect of the allotted premises, the community, and thereby allow to renovate the development of community basis, but the same was refused, my lord.
No, you file a proper application for the authority. We'll give them a direction to dispose of.
Until then, my lord.
Till then what?
No allotment. We approach, my lord. Or notice may be issued, my lord, till then we approach.
No. Till then, we do not, without knowing what is the status, how do we give you an interim order?
Normally,
How have you shown us that you are utilizing that hall for whatever purposes you are utilizing it? Where have you shown that this hall has been properly utilized? In fact, you have made a statement at para 7 that you are willing to clear all the dues. You may not have cleared the dues. That is why they have taken it away. Para 7, your statement.
yes, my lord. They had refused, my lord. Earlier town committee, because my lord, as per the resolution, my lord, they have said, my lord, they kindly see the resolution at page, my lord.
Yes, Mr. Goswami, please get your instruction. See what is the position here. A list on 17th December.
Till then,
Not till then, what till then?
otherwise, my lord, the new board has come, my lord,
New
because
board. Till next date, allotment, if any, to the, what is that, community hall,
community.
which was earlier allotted by the Doboka Town Committee, stated to have been allotted by the Doboka Town Committee to the petitioner, shall not be re-allotted to any other person by the municipal board.
Honestly.
Delimitation, fixed on 17/12.
It's not pertaining to delimitation.
That-
Malad, the petitioners, Malad, before your lordships,
Huh.
they're all inhabitants within the jurisdiction of a Gao Panchayat, namely Borwa Gao Panchayat, Malad. Now they are aggrieved by the notification dated 15/10/2024, by which, Malad, a delimitation exercise was carried out, but they are not aggrieved with the delimitation exercise, Malad. So what had happened, Malad, pursuant to the delimitation exercise, the government, my lords, the department had unilaterally changed the name of the Gao Panchayat, my lord, without any public consultation. The Gao Panchayat was Borwa Gao Panchayat, my lord, which has a historical significance. I have explained it in my writ petition, my lord.
Where is that?
My lord,
By which?
my lord, order dated 15/10, Annexure B, page 36, my lord.
Page 37,
36, my lord.
36. Where is the name of your Gaon Panchayat?
My lord would come to page 37, my lord. From the bottom, yeah, Borwa Gaon Bamunbari. Now, this word Bamunbari was included, my lord, which was not earlier there, my lord. Now, if my lord may kindly turn to page 36 again, my lord. Without going into the other aspect, my lord, I'm directly arguing on the legal, the validity of the action, my lord.
Yes.
Page 36. In exercise of powers conferred under subsection 2 of section 5 of the Assam Panchayat Act so and so, and in pursuance to the cabinet decision taken in its meeting dated so and so, the governor of Assam is pleased to notify the following Gao Panchayats along with their corresponding villages in the Kamrup district. If my lords may kindly take up the Panchayat Act for a moment, my lord.
Panchayat.
And surprisingly, my lords, none of the other names.
Ye wala. Yeah. Yes.
And surprisingly, my lords, none of the other names of Gao Panchayats, which is contained in the notification, has been changed apart from the Gao Panchayat of the petitioner.
Yes.
My lord may come. This order has been issued purportedly under 5(2), as I've read it out, my lord. 5(2) of the Panchayat Act.
Yes.
My lord, I won't trouble your lordship with the entire section. The relevant portion 5(2). I'll read 5 subsection 2. After consultation with the Gao Panchayat, if it has already been established, the government may by similar notification at any time, include or exclude from any village, any local area or otherwise from the limit of any village, declare that any local area shall cease to be a village and thereupon the local area shall also be excluded from the limit of the village so altered. Now 5.2 empowers the government, man, with all due respect, what I've understood is to declare that a certain village would be included in the Gaon Panchayat or would be excluded from the Gaon Panchayat. And second, it shall declare, man, if a Gaon Panchayat ceases to be a Gaon, if a village ceases to be a village, man. Now this, the section 5.2 does not empower the government to change the name of the Gaon Panchayat, man.
Where is the provision that there is a bar? It cannot be changed.
It's exceeding the jurisdiction, Malaj. The change of the Gaon Panchayat name could not have been done.
Earlier, how many villages were included in Borua Gaon?
Well, we are not agreed with that. There are other Gaon because normally what happens, Malaj, name of the Gaon Panchayat is derived from a revenue village of the Panchayat, Malaj. If my lord peruses the page 37 again, there are 1, 2, 3, 4, 5, 6, 7 villages, my lord. And none of the villages, revenue villages, the word Bamunbari is not there in any of the villages, my lord. And without any justification, does not justify the change of the name.
No, that's okay. But to file a writ, you must establish a legal right.
Yes,
Where
my
is
lord.
that right?
Legal right, that is the legal right.
What?
Well, the statutory violation is there, my lord.
Where is
the statute does not allow to change the name, my lord, unilaterally.
Where does it allow? Where does it expressly debar that you cannot change?
Well, in that case, my lord,
Where does it say that this is the procedure while naming a village?
No, my lord, they are exercising powers under 5.2. Now the powers under 5.2 is circumscribed, my lord.
You are not agreed by that. You are not agreed by inclusion or exclusion.
We're not agreed by the inclusion of exclusion.
By the name.
My lord, in the garb of 5.2, they have exceeded the jurisdiction by changing the name, my lord. That could not have been done, my lord.
How is the name to be conferred in the first place? Under what proof?
My lord?
Let us say there is a group of villages and a Gaon Panchayat is to be established.
Yes.
How does the government decide?
Normally, my lord, there is a consultation within the people residing in the jurisdiction, my lord.
Right. So, your grievance can be that there was no consultation.
And my lord, there is no consultation, and plus, my lord, 5.2 does not, with all due respect, my lord, 5.2 does not empower the government to change.
It may not empower, but it doesn't bar. Because it has got no reference to naming of the village.
Yes, in that case, my lord, by taking recourse to 5.2, the powers of the government would be unlimited, my lord. They can do anything on that.
5.2 may have been wrongly quoted.
Yes.
May have been wrongly quoted.
My lord,
you tell us that from this provision or that provision, the naming of the village has to be in this particular procedure. What?
Yes, my lord, I'll come to that. But my lord, 5.2, first of all, does not empower the government to change the name. Now, my lord, may kindly take up the Assam Panchayat Constitution Rules, 1995, in the same book, my lord. My lord, just give me a moment, I'll find out the provision. What, sir? Yes. Yes, my lord. My lord, if it's the same book, page 130, my lord, Rule 10.
10.
Rule 10.
Yes.
Rule 10. Name, serial number of Gaon Panchayat and the Anchalik Panchayat and the Zilla Parishad constituencies. Deputy Commissioner and the subdivisional officer, as the case may be, shall after fixing number of constituencies under Rule 6, 7, and 8 of these rules, allot an appropriate name to each of such constituency on consideration of the local name of the village or villages or part of the villages falling in such constituency. All such constituencies of Gaon Panchayat, Anchalik Panchayat, Zilla Panchayat shall be arranged by assigning a serial number against the...
This is for the purpose of election.
Not for name also, my lord. The heading, my lord, would see, and again, I'll read it again, my lord. Deputy Commissioner and the subdivisional officer, SDO, as the case may be, shall after fixing the number of constituencies under Rule 6, 7, and 8 of these rules, allot an appropriate name to each constituency on consideration of the local name of the village or villages or part of the villages in such constituency. Now, my lords, with all due respect, my lords, if the name could have been changed, the power has been vested upon the deputy commissioner and the SDO. This is a specific power. The deputy commissioner has been vested with that power, my lords. That has not been exercised in the instant case. And again, my lords, if the name has to be changed, it has to have some reference with the revenue villages also.
No. This argument you are making is not discernible from the rules or from the act. It may be a very convincing argument, but you'll have to tell us on what basis you are making this argument that it violates your legal rights.
No,
Some
violation,
source, somewhere.
the violation of legal right, my lord. First of all, we have made a representation, my lord. And the with all due respect, my lord, if a statutory rule or statutory act is violated, and that is
It is not a case that your entire name has been changed.
yes.
It is a case where
Yes.
something has been added.
Yes, my lord. My lord, the Gaon Panchayat name is connected with the identity of the
There are
inhabitants,
so
my lord.
many changes to names in cities and states and all that. So
That cannot be arbitrary and irrational, my
do
lord.
you expect
Without any
every
justification.
citizen to be consulted? about
Without
change
any
of names?
justification. Now, what they do, my lord,
It may hurt your feelings
Yes,
for whatever reason, but
and my legal right as well, my lord.
that is what we are asking you.
Yes.
How have you
Yes.
crystallized your legal
Yes, my lord.
rights?
By
From which source?
yes, my lord, I'm also on parity also, my lord. By taking recourse to 5-2, they could not have
Alright,
changed the
but
name of the.
Mr. E. Montolan at counsel for the petitioner, Mr. Esbito, appearing for the Panchayat and Rural Development, respondent number 1.
I'm
And
three and four.
Mr. N. Swami for 3 and 4. Steps on respondent 5 by registered post 80 as well as utility courts. Since respective councils appear for 1, 2, 3, 4, notices are waived, extra copies be furnished. Let the respondents complete their instructions and file necessary affidavit.
My lord, for respondent number 5, I can appear, my lord.
You can appear.
Panchayat, yes.
Okay. Then
But
he
notice has to go, it's a Gaon Panchayat, my lord.
Gaon Panchayat, I can appear.
It's his call. If he wants to
The
appear.
autonomous bodies, my lord, Gaon Panchayat, they can.
Why are you objecting to his appearance? If he wants to appear, let him appear. How are you concerned?
That would be a conflict of interest, my lord. How
You
can
argue that. You argue that. Why are you preventing him from appearing if he says he is
Because
competent
all
to
due
appear?
respect, the
at
Gaon Panchayat
present,
is
my
of the
lord,
government.
There are no precedents, my lord.
You have the right to raise these objections.
I'll raise that objection. I was just
As and
pointing it
when
out.
the matter is pointed out. Today he is accepting notice. He says he is instructed to accept notice. Why are you objecting to that?
He'll appear for
You
the
are
PNRD department.
You are apprehending that there will be conflict of
Then
interest.
there is, he cannot appear for the Gaon Panchayat.
Under what
It's an
provision?
autonomous body. I'll come to the constitution of Gaon
So
Panchayat.
what?
It's their prerogative whom
It
to
is
appoint.
his call to appear or not to appear. Your argument for conflict of interest.
I'll file an additional affidavit on that. I'll place it on record.
You may place it on record, but that is subject to there being any materials to show that there is a conflict of interest.
Well, it's like the public prosecutor appearing for the complainant also. Same
Not
thing.
like
He appears for respondent number 5 also.
1, 2, and 5.
1, 2, and 5. 3 and 4, Mr. N. provides. Let the respondents complete their instructions and file necessary affidavits. Matter be listed after returnable date.
This is interim prayer, my lord.
What?
Till that date, my lord, they are trying to change the board of the Gaon Panchayat office, my lord. That may not be done, my lord. Till the next date, my lord.
No. They let them take whatever steps.
And I was objecting because the Gaon Panchayat itself, I've instruction, my lord. Gaon Panchayat itself is aggrieved by the change of the name, my lord.
So let the Gaon Panchayat appear and say that they are not happy with their council. Who's stopping them? Who's stopping them?
My lord, may I submit on this point, my lord? At present, there are no presidents, elected presidents, my lord.
How
All
is it
the
relevant, my
official
lord?
secretary is the head of the.
Let the matter be listed on in January. Give us a date in January. Matter be listed on 10th of January. Interim prayer, if any, shall be considered on the next.
Till then, my lord, the name may not be changed. It's already there. Name of the Gaon Panchayat.
We
may
have
not be-
given you the liberty interim order. Your whole prayer is for a direction not to change the name, and you want an interim order on that. That will amount to giving you the final relief.
No, just the name of the board of the signboard of the Gaon Panchayat, my lord. Nothing else, my lord.
We are a writ court. We look into your violation of legal rights.
I'm deeply obliged.
Item 22.
The petitioner's husband, my lord, he died, my lord, while on COVID duty, my lord, because of COVID contamination.
We had disposed of similar matters where there is a,
Therefore, the disposal of this.
they will have to examine and take steps to release their amount, is it?
Otherwise, my lord, a similar matter was listed few days back.
That's right.
The lordship was pleased to fix that matter on 16th.
Oh,
My lord, for seeking instruction. Here, lordship will
but we had disposed of one matter also.
dispose of, my lord, that matter.
Your husband
Husband.
was working in the fire and.
Yes, fire department, my lord. He was on COVID duty, my lord.
And where is that notification?
My lord, notification, my lord, is there, my lord, page 33, my lord.
26.
It starts
Yes,
from
28 is the office memorandum, my lord.
Lordship,
26 is over there, my lord. So the office member, the gadget notification is 28, my lord.
already proposal has been sent. If lordship may straight away come to page 33 of the requisition. Page 33, this is a proposal, my lord, from DC Baksa Musalpur. So under the scheme of the notification, the proposal has to come from the deputy commissioner, which has been done in the instant case. Let me get the instruction on this, my lord, page 33. And lordship can fix it on 16th.
We dispose it of directing the commissioner to release the payment if found eligible, otherwise eligible. Is he or is he not eligible?
Appears to be eligible prima facie, my lord.
Because the proposal has been
Yes,
sent.
everything is there. But whether we have received this proposal or not, my lord, in fact.
So we'll direct them to. We will direct the authority to examine the matter and pass necessary orders on this. What else is required?
Otherwise, my lord, since that matter is fixed on similar matter.
When is it fixed?
On 16th.
All right, list on 16. Let him get the instruction. Mr. Arbitrator, appearing for respondent, similar matter is fixed on 16. Let this matter be listed. Do you have the number of that matter?
WPC 6440
WPC 6440 of 2024. Yes.
Item 23.
Yes.
Petitioner before your lordship is a partnership firm.
You'll have to pay the dues.
Yes.
You have to pay the dues.
So there is no question of dues, my lord. The lordship will come to, my lord, I will come to that, my lord. There is no question of dues, my lord. Dues is not a factor here, my lord. So I purchased a plot of land along with a factory. So getting the all necessary permission, my lord, sale deed was done. Thereafter, my lord, land is also muted in my name.
Who's appearing for T-board?
T-board, my lord.
Is there any counsel?
No, there is no counsel. No, my lord, especially annexure 54, page 54, annexure 14 is a without jurisdiction, my lord. He cannot, my lord, already, my lord, your lordship kindly see page 54, my lord.
Yes.
Page 54, my lord, has your lordship got it, my lord. Page 54, annexure 14. The Assistant Director T Development T Board India Tinsukia. Subject regarding forwarding of petition with reference of the subject cited above. The please find here with the petition of submitted by the President Secretary of All Assam Tea Grower Association, Tinsukia District Committee alleging non-clearance of the payment of the supplied green leaf by Siri Manos Buraguhai, proprietor of MS Redolence Tea Industry. Where it is alleged that the says Manos Buraguhai has been planning to sell the factory. In this regard, you are hereby directed to hold the proceeding of the selling and purchase of the said factory with immediate effect until the further instruction from this undersigned. It is pertinent to mention here that surface case is also being filed by the Indian Bank, Tinsukia Bank against MS Erosion Tea Industries. So this issued, my lord, by the additional deputy commissioner, who says no authority to deal with a private dispute, my lord. So, my lord, your lordship kindly see that there is a total non-application of mine, my lord, because already, my lord, sale was, my lord, after getting due permission, my lord, that land was mutated, land was sale deed was done, my lord, and that your lordship kindly see sale may be, my lord, stall. Selling and purchase of the said factories, but it is already been done, my lord. I think due permission from the same office, my lord. Now, my lord, dear lordship, last line, my lord, the surface case is filed by the T-board. That is also, my lord, absolutely false, my lord, because the next page, my lord, page 55, annex 15, my lord. Annex 15, my lord, that is a certificate issued by the T manager, Indian Bank, my lord. There is no dues of the Manas, my lord, that before selling, my lord. So after getting all these things, my lord, now, my lord, somebody complained, no, what difficulty is now, my lord, I cannot produce the, my lord, tea, because I have to get by, as per this rule, my lord, I have to get permission from the change of ownership certificate. Until and unless that is not given by the tea board, my lord, I will not, cannot produce, because,
Therefore, we wanted to find out who's for T-board. There is no council
my lord,
for T-board.
no, my lord, that additional deputy commissioner, he is, my lord, appearing, my lord, government, but under what authority he is issuing this, my lord? Right, my lord.
Get your instructions here. But what about T-board?
My lord, T-board, my lord, notice has to go.
Heard Mr. T.J. Montol and Senior Council, assisted by MS T. Sharma. Also heard Mr. N. Goswami, and Government Advocate, appearing to respond number 1,
7 and 8.
number 2,
Lordship. And then
1, 7 and 8. Mr. N. Polita appearing for number 10, respondent number 2. Since the learned councils have acted on behalf of respondent 1, 2, 7 and 8, notices are waived. Extra copies be furnished in a period of 1 week from today. Steps on respondent 3, 4, 5, 6 by usual course registered post within 1 week from today. The grievance of the petitioner is that the process of sale and purchase by the petitioner. Petitioner is selling.
No, petitioner is buying.
Buying. Petitioner.
He is buying. He brought, my lord.
Huh?
He is brought, my lord. Yes.
He is being sold.
He is a purchaser. Petitioner is a purchaser. He has already brought, my lord. Only change of ownership certificate has not been issued by the respondent authority, my lord. Because of this letter, my lord, of the circular.
Petitioner company has already purchased one that is also a tea garden or what?
No, this is a plot. It is actually tea factory only.
Factory.
Well, the land along with the tea factory, it is popularly known as
Along with the tea factory under the name and style measures Redolence Tea Industries. Stop. The said tea factory having been purchased was required to complete the procedures as required under law by the Tea Board of India. Stop. During the said proceedings, there were communications issued by the additional deputy commissioner raising objections that there are surfacey matters pending against the purchasee company, purchasee entity. Stop.
No.
Under such circumstances, the Tea Board has not issued. What is to be issued by the Tea Board?
Tea Board, my lord, they have to change of ownership certificate, my lord.
Have not issued the change of ownership certificate, and as a consequence thereof, the
We cannot
petitioner
produce
also having purchased Mrs. Redolence Tea Industry comprising of the factory and the land is unable to operate the same. let the matter be listed again after the returnable date.
My lord, actually, I pay for an interim one because, my lord, your lordship can the additional deputy commissioner. Under what authority he has issued this letter, my lord? So that he, because your lordship can receive from the same office, my lord, giving permission to my lord, sale, my lord. And surface, there is nothing, my lord, pending, my lord. Where from he's got it, my lord? It's a private dispute, my lord. How he can entertain, my lord? Without hearing me, my lord. And already process has been completed, my lord. Your lordship kindly say process regarding the, you are hereby directed the proceedings of the selling and purchase has been stopped. But already that has been done, my lord. It is already acted upon.
No, but if you are praying for, your prayer is for setting aside of that letter,
My lord,
Deputy Commissioner.
my lord.
Now, if we stay it and in the meantime, your transfer.
No,
of
my lord, why I am
ownership-
submitting, my lord? He has actually, my lord, keyboard also doing, my lord, is a illegality because they cannot act it upon this, my lord. But since it is a hurdle, my lord, so since I am challenging the authority, my lord, because I have taken a loan of 550 lakhs. Now, my lord, I am, my lord, giving salary to those.
You find a way to serve copies on the T-board. Within 1 week, we will take up the matter again. And
Then, my lord, your lordship kindly in the notice on in interim PR also, my lord, district.
Right. No, we'll do that. What we are.
My lord,
Your prayer is for setting aside that letter.
My lord.
Your grievance is that they have not been registered. Your change of ownership. has
So
not-
there be noise because of this
Now,
letter.
if we grant you an interim order staying that letter,
No, my lord, when it is a without jurisdiction, they can, my lord.
that is what we are supposed to find out. Now, the interim stage, granting an order, staying it will amount to giving you a final relief.
No, that, my lord, actually, that is a consequential relief,
can
my lord.
only say.
My lord,
we
if
can
your lordship, my lord,
No,
always,
we can only say that during the pendency of the writ petition,
My lord.
the change of ownership
it can be barred.
it can be, if the T-board considers
My
change
lord.
of ownership, then
My
it shall
lord.
not be a bar.
That can be.
Fixed on so and so returnable date. Pendency of the writ petition shall not be a bar for the T-board to proceed for change of ownership as per the provision of law.
My lord, let it be returnable, that my lord, your lordship.
Matter be listed on 22nd, 23rd, 24th January,
My lord.
24th of January.
Yep.
May please, your lordship. Here, my lord, I was briefed by an order by which my arm license has been cancelled, my lord. I have filed an appeal, and in the appeal was also decided whereby the order of cancelling my gun license has been upheld, my lord. And the reason cited that some cases is pending against me, 5 cases in the in the impugn order, my lord. The impugn order is at page number 56, my lord. My gun license has been, validity has been expired on 2019. I applied, my lord, and thereafter my license was revoked, my lord. Page number 56, Annex 5 is the first order, my lord. In paragraph 2 from the bottom, my lord, it was written, whereas as per police verification report, it is seen that several number of cases have been registered against the petitioner, which cannot be a justifiable ground for possessing an armed license with the petitioner. There are 5 cases, my lord, against me. Out of 5, my lord, 2 has already been given final reports. And so far, the other 3 is concerned that has already been stated by this honorable court. Thereafter, my lord, I have filed an appeal. And in that appeal, my lord, order has been passed. And that order is at page number 74, my lord. And operational portion is from page number 76, my lord. From paragraph 2nd from the bottom, my lord. On 27/5/2024, the applicant has submitted a representation along with some documents providing further clarification on the appeal, by which it is entirely urged to review his case in accordance with principle of justice and fairness. The DCP has submitted a report on 5/6/2024, providing the status of the 5 cases, stating that in 2 cases, final reports have been submitted and other 3 cases have been transferred to BIEO, Assam. Therefore, a report has been sought from the IGP BIEO Assam in connection with 3 cases registered against the appellant. and also requested their views regarding the renewal of arm license of Balwant Singh alias Balban Bhama. In the meantime, the DCP Guwahati by his letter dated so and so submitted an addendum to the effect that since several cases were registered against Balwant Singh, only Balban Bhama renewal of arm license may not be granted. The SPBIEO has submitted a report dated so and so wherein it stated that 3 cases which were registered against Balwant Singh alias Balban Bhama in connection with commission of serious criminal offence punishable up to 7 years of imprisonment of either description and fine are pending. It would not be in the interest of public safety, peace and order to consider a matter of renewal of his arm license till conclusion of the said criminal cases. These 3 criminal cases earlier it was registered as a police case, my lord. And I filed criminal petitions in against those police cases, and it was stayed by this honorable court.
All right, we'll issue notice at this stage. Third, then counsel to the petitioner. Petitioner is before the court by non-issuance of a gun license, which the petitioner has applied for. Being agreed, he had prepared an appeal. The appeal also came to be rejected by, where is the appellate order?
Appellant order is at page number 74.
Came to be rejected by order dated 24th of July, 2024. Where I issue notice, written about 4 weeks, Mr. Swami appears on behalf of all the respondents. Since government advocate appears, represents all the respondents, officers are waived, extra copies be furnished.
Interim order may be given, my lord, because otherwise.
What is that interim order?
Suspension of the courts, suspension of this order, interim order. Because, my lord, so far the act is concerned, the act clearly reflects that if license can be.
Notice on the interim grant. Returnable on the same date, list on 10th of January.
Hello, please.
Item 25. Please, Lordship. GST matter, Lordship, I had filed an appeal. The appeal authority has passed an perverse and mechanical order, Lordship, without application of mind. The appeal order is at page 83, Lordship.
Yes.
If your Lordship peruses, Lordship, the date of order, the appeal was filed on the second line, 29/8/2024, Lordship. And the date of order impugned in appeal, order date, line number 5, Lordship, 29/4/24. But in the body of the order, Lordship will find second para, the order against which the instant petition has been filed was passed on 19/12/23. This is wrongly quoted, Lordship. Appellant filed the petition on 21/5/24. This is again wrongly quoted, Lordship. So this is a perverse order, Lordship. The dates of the demand order impugned in the appeal as well as the date of filing of appeal, both have been quoted wrongly, Lordship.
What is the date of the order?
Date of order which was impugned in appeal, Lordship, it is 29/4/24.
What is reflected here?
It is reflected 19/12/23, Lordship.
19/12.
And the appeal was filed on 29/8/24, Lordship. And it is reflected as 21/5/24, Lordship. Appeal is permissible usually within 3 months, Lordship, and extended time of 1 month. This order has been passed on the analogy that the appeal was filed beyond 4 months and the appeal was dismissed. But the appeal was filed on the last day of the 4th month, Lordship.
Yes, Mr. Govind.
The court instruction I will have to take, because apparent some discrepancy is there.
Until then, Lordship, I pray for no coercive action.
Heard learned counsel to the parties, petitioner is before this court, putting to challenge the order dated.
The order is dated
29/4. 2024. It is submitted that the appeal was rejected and the order impugned before the appellate authority as well as the date of the filing of the appeal memo. Dates of the filing of appeal memo have been wrongly quoted. Stop, he submits that. A bare perusal of the appellate order reveals that there is no application of mind. Dates can always be corrected.
Lordship. But
So it's a-
after disposal of appeal, Lordship, until and unless the court interferes, it cannot be corrected, Lordship. He has taken a ground, Lordship, that after 4 months the appeal has been filed, but I have filed it on the last day of the 4 months within the limit.
It is further submitted that the appeal was dismissed on the ground of limitation.
Lordship, that
on
the
ground
instant
that it
petition.
was filed post the limitation period, which is 4 months from the date of the order of assessment. Stop. The counsel for the petitioner, referring to the appeal memo, submits that the date of the appeal was filed on 29/10/2024.
Appeal was filed 29/8, Lordship.
Huh?
29/8, the date of filing of appeal. And this order was passed
What
on
is that?
29.
Page 82?
Page 82, Lordship. Serial number 7 is the date of rejection of appeal, Lordship. And serial number 2 is the date of filing of appeal, Lordship.
Date of filing as reflected in the acknowledgement issued by the department is reflected as 29/8/2024.
Lordship.
And the date of rejection of the appeal is shown as 29/10/2024. So, when was the order of the assessment authority?
29/4/24, Lordship.
The impugned order. The order impugned before the appellate authority was issued on 29/4/2024.
Lordship.
He therefore submits that it is within the limitation period and not to have been rejected on the same ground. So, Mr. B. Gogoi, standing counsel, GST, submits that he would like to obtain instructions in the matter. When do you want it?
17th, Lordship.
Well, before vacation, I can.
17th. This is the matter
Only
of
thing was one copy.
extra copy be furnished during the course of the day on the respondent counsel to obtain instruction. Till 17th, no action be taken on the basis of the order dated so and so passed by the appellate authority.
Lordship.
Supplementary list, item 65.
Yes, pollution board.
They are supposed to apprise the court about the
Where is
action
the
taken
pollution
on
board?
the representation.
Where is Mr. Burua? S. Burua.
Not.
Call him.
Not.
We'll keep it aside for the time being.
Not.
Item 67.
Roll S. Burua. Siddharth Burua. Pollution control board.
May I please, Your Lordship. Why this is excellent eviction notice. Your Lordship, page 28, eviction notice. In vernacular, Your Lordship, on page 30. Nothing has been mentioned about reason and no provision of.
Who are you? Who are you?
Page 30.
Who are you?
We are occupying the land, Your Lordship.
Since when?
Since Your Lordship, 2009, 2010.
Then?
And there's
Where
notice.
is the notice?
Page 30, Your Lordship.
30.
30. Nothing has mentioned why it's required, and this land is not a reserve land and nothing is planned. No provision is mentioned in simple notice. And Your Lordship is aware about the recent judgment of the Honorable Appellate Court. It is also highlighted guideline given by this.
Yes, instructions.
Your Lordship, page, recent judgment, page 89. The recent judgment of its court.
Oh, that is okay, but we need to have the instructions as to why it has been there. How many notices have been issued? What orders have been passed? Heard Mr. Learned counsel for the petitioner appearing for the. You see, the problem with the respondents is that your instructions don't come. Therefore, we are required to pass an interim order.
First thing.
We know, but unless you get instructions, there's no point in keeping the matter before the vacation.
Short.
Not the right instruction.
When?
I'll bring lots.
When can you get it?
Lordship on 18 Lordship.
No, Your Lordship. It is 15 days notice. 10 will be last date, Your Lordship. Notice is issued on 25/11, 10/12.
Why have you come today?
But we have received.
25/11 it was issued. When did you receive it?
I have received, Your Lordship. They have surface present, they have hanged, Your Lordship.
Then when did it come to your notice that the notice dated 25/11 was there? When did it come to your notice?
Notice of 30, Your Lordship. 30.
30 after 5 days.
Because
Where have you stated?
Not, I have
Where
not,
is that statement?
not stated.
Then petitioners are aggrieved by the notice dated 25/11/2024, whereby they have been asked to vacate the land which is under their possession within 15 days. Stop. It is submitted that this land is under the occupation of the petitioners within for last several years, and they have applied for electricity connection on the said land, and the petitioners and the family members have been staying in the said land. Stop. The petitioners have also filed their applications under the scheme within courts Bokundora for the settlement of the above plot of land, but no response has been received. Stop. Being thus situated, the impugned notice has been issued. Being aggrieved, the petitioners are before this court, praying for adequate orders, appropriate orders, that before they are vacated, alternative plot of land should be allotted to them for their resettlement, and end of rigor, considering their long stay on the land, the said plot of land ought to have been settled with them on the basis of the applications filed under the Bokundora scheme. Mr. N. Goswami appearing, and Ms. G. Hazarika appearing for respondent 1, and Mr. N. Goswami appearing for respondent 2 and 3 submit that they would like to obtain their instructions. Let the matter be listed on when? 17th December.
Till date, any protection, no court.
Stop. Till the next date fixed, respondents will not proceed against the petitioners on the basis of the notice dated 25/11/2024.
They have received the notice on 25/11.
We don't know. Extra copies be furnished within the course of the day to the respondents to complete their instructions in the matter.
May I please, Your Lordship? Petitioner is a elected chairman of the Titabo Municipal Board, Lordship. 28/6/2024, 8th Ward Commissioner has brought a no confidence motion. Requisition has been made against the petitioner, Lordship. Accordingly, 25/7/2024, a resolution adopted against the petitioner, Lordship. The resolution was not approved by the government, Lordship. Being on same date, another resolution was adopted by the respondent authority. Respondent number 8 was selected as a chairman of the Titabo Municipal Board, Lordship. In this regard, Lordship, being aggrieved, petitioner approached before this court by filing a writ petition, WBC no 4754, Lordship.
What order was passed?
Lordship, during the pendency of the litigation, respondent have taken a new decision against the same subject matter, Lordship. Lordship, order was, Lordship, 76 page, Lordship.
Yes. This petition was infractuous.
Yes, Lord. Infractuous second meeting was held on respondent number 8 was selected, Lordship. Another 25/7/2024 resolution was not infractuous, Lordship.
Now?
Now, Lordship, respondent number 8, 18/10/2024 notice issue calling upon meeting on 21/10/2024, Lordship. The said meeting, respondent 8 was resigned from the as a chairman of the Titapur Municipal Board, Lordship. And thereafter, Lordship 22/10 and further adopted a resolution to new election of the for the post of chairman, Lordship. Again, Lordship, Vice President on 22/10/2024, Vice President of Titapur Municipal Board in terms of the section 41(2) call a meeting for new election, Lordship. Accordingly, 25/10/2024, respondent number 8 was again chairman of the said municipality board, Lordship. My humble submission is, Lordship, that without approval, 25/2025/7.
Heard that counsel for the petitioner, this petition is directed by the petitioner.
Without removal of the petitioner, Lordship, in terms of section.
By which resolution?
Lord, 25/7/2024 as well as 25/10/2024, Lordship.
Page number?
Page, Lordship. Page annexure, Lordship, F, Lordship.
Page number?
Page, Lordship, 40, Lordship. Is the resolution, Lordship, 25/7/2024, Lordship.
But this resolution was withdrawn, recalled, no.
No, Lordship.
The resolution dated 25/7/2024.
Without removal of the present petitioner, Lordship, 41(2) subsection cannot be whole a meeting for election, Lordship.
For removal of the petitioner from the post of chairperson of Titapur Municipal. Titapur?
Municipal Board, Lordship.
Municipality Board. Stop. Then where is the second resolution?
Second resolution already court already said that it is an infectious, Lordship.
All right. It is submitted that this resolution was not accepted by the government.
Yes, Lordship.
As required under section 41.
Yes, Lordship.
41 of the Municipality Act. So it is submitted that unless the same is approved by the government, the private respondent number 8 cannot function as the chairperson of the Titapur Municipality Board. Accordingly, the writ petition has been filed challenging the resolution as well as the appointment of this private respondent. There are death notice issue returnable 4 weeks. Mr. Goswami appears for respondent 1, 2,
5,
3, 4, 5,
and 7.
And 7. Steps on respondent 6 and 8 by equal court registered post.
Lordship, kindly consider the interview, Lordship.
One week. No, what interim prayer can we give you?
Lordship,
there has been some, rightly, wrongly, there is a resolution.
Lordship.
You have been removed.
Lordship.
Now you are challenging the resolution.
Lordship, I have not removed, Lordship. That 25/7/2024 order has not been communicated by the higher official, but without approval by the government, how can I remove from the said post, Lordship?
Where is that order again? Page number 40.
Yes, Lordship. And second meeting whole respondent number was selected, that was the infectious, Lordship. As per new decision had taken by the respondent authority, Lordship.
Let them obtain the instructions, we will examine the matter.
Lordship, during the pendency of the litigation without interim pair passed by this honorable court, that was the time, but respondent authority have taken a pick and choose policy, but petitioner agreed by again and again, Lordship.
So let them get their instructions, we will see the matter again. Let it come in January, first week.
Lordship, kindly, Lordship, interim prayer maybe kindly, Lordship.
No. Interim prayer will amount to giving you a final relief.
Yes, sir.
You are praying that this resolution, unless approved, cannot be implemented. That is your prayer.
Lordship.
So we are asking them to give their instructions to find out. If it is found that it is in violation of 41,
Lordship.
this order will go and your tenure as the chairman will continue from the.
Lordship, 41 subsection 1 is very much clearly
We
stated.
will
that-
examine that. Let the respondents file their notices, responses, notice on the interim prayer. Matter be listed on 6th of January 2025. Notice on interim prayer, 6th of January.
In this case, Your Lordship, I have taken steps. There is no any official note with regard to service of notice.
It is
So
on respondent 6.
6. So maybe you await it, Your
It
Lordship.
is submitted by the learned counsel for the respondent number 6 that steps have been effected on respondent 6. Stop office to verify and make necessary thought. Let the matter be listed after 3 weeks. Let the matter be listed on 6th of January. Interim order passed earlier will continue till the next date. Mr. N. Goswami appeals for the respondent.
On 6th, Your Lordship.
6th January.
Can it be after 10th of January, Your Lordship?
No, you are on an interim order.
No, there is interim order because after 10 I will be available, Your Lordship. Therefore, I am saying. Your Lordship.
Let somebody appear on 6th of January. You are enjoying an interim order. Yes.
Lordship, I'm appearing on behalf of Mr. Esbora. He's on legs. This matter may be tagged with another case. Contempt case number 376. Public 24.
You have filed a compliance affidavit.
Yes, Your Lordship. Fine. It is part of the record.
It is submitted that this matter be listed along with contempt case number
376 oblique 24.
376 of 2024. Let the matter be listed in January. Apply it. Yes, what is this I?
IA has been filed for amendment to the requisition. Some silly mistakes are there, madam. That we have to be amended.
Who's for the respondents?
Respondents are all Revenue Department. Revenue Department, State of Assam.
Any objection? No. This
Only that number, pata number has been.
This I has been filed seeking amendment of the writ petition being WPC 4375 of 2020. So the respondents represented by the council appearing for the Revenue Department as well as by the learned government advocate does not object. Prayer for amendment. Accordingly, I stand allowed. Petitioner is permitted to make the necessary amendments as reflected in the IA. So the petitioner will file
Amended requisition.
amended petition incorporating the amendments prayed for in the in this IA. In paragraph number 2, paragraph 5.
Yes, madam.
And third line of the synopsis, as well as by the prayers, as well as in the prayer portion. So let the amended petition be filed within 4 weeks.
Obliged.
I said allowed disposed of.
Obliged.
Writ petition we write in view of IA, order passed in IA. Writ petition is directed to be listed after the registry receives a copy of the amended petition as permitted to be filed.
Obliged.
Time being item 3.
I'm so sorry. In fact, I missed the matter because the name hasn't been reflected. But
so you don't have your instruction.
I have already communicated on the basis of the previous order, which we are to yet to have it. But ultimately, the petitioner is harping upon a rule which has never been legislated. This rule is only a guideline that the board is having for their own internal use. So there is no brick clean rule.
Lordship will find the rule is developed by the Pollution Control Board itself. Page number 15. And if there is no such rule, then how?
There is no
individual-
rule.
Yes.
There is no
Lordship, may I submit one more line, Lordship? If,
What,
yes,
they are issuing notice today.
and I'm arguing for the interim prayer.
What is your interim prayer?
The operation may remain suspended.
That
Because
is
it is
also
closing.
your final prayer. The operation of the brick kiln operated by respondent 5.
Yes.
So have you served notice on respondent 5?
No, Lordship,
Then
because
Federal Council for the parties issue notice. Written about 4 weeks. Mr. Who appears for forest? Mr. D. Gugoi appears for respondent number 1. Mr. S. Borua for respondent number 2, 3, 4. Steps on respondent number 5 by usual course registered post. You are appearing for all the respondents or
I'm
only?
appearing only for the petition board.
Pollution board, okay. Respondent number 2, S. Borua, MS S. Borua for respondent 3 and 4. Mr. S. Borua for 2, MS S. Borua for 3 and 4. Steps on respondent 5 by usual course registered post 80 within 1 week from today. Let the matter be listed after the returnable date. Prayer for interim will be considered on the next returnable
next
date.
returnable date. Lordship, may I pray for a fixed date, Lordship.
20 January 20.
Lordship.
Item 31. For the timing now.
No timing today. Matter be listed next week. The prayer of the council for the petition.
I appear for the petition.
Mr. Monik appears for APTC.
Item 32 and 33.
Yes, Lordship, my lord, we are agreed by this impugn order 16/2024. The demarcation of the two duct number is directed to be.
You have not taken steps as per the order of this court. That is the office note.
In respect of resolution number 7.
You have taken steps.
My lord.
Petitioner is permitted 3 weeks' time to take steps in terms of the order dated 4/11/2024. Mr.
A.K. Azad.
A.K. Azad appears for
4, 5 and 6, madam.
the respondent 4, 5 and 6. MS S. Borua for government. Ms. S. Borua for respondent number 2 and 3. And G. Hazarika for respondent number 1. MJ Borua for.
Item 33.
32 and 33, these are together.
Thirty-two and 33, both 34.
May it please your lordship. Lordship may kindly pass over the matter for the day, Lord. The engaged counsel had to leave the court due to some medical emergencies.
You can take it on Monday or Tuesday.
My lord,
Yes.
I am appearing for respondent number 3, my lord. I am filing the affidavit in opposition also today.
Okay. All right, then you'll need more time for that. You are appearing for respondent 3.
3.
All right. Mr. S.S. Goswami appears for respondent number 3. He submits that he's received instructions and would like to file affidavit.
My lord, I'll file it today, my lord. I think ready. I'll start the copy now. Okay.
He submits that he would like to file the affidavit by today. MS RDP for respondent 1. 1, 2 and 5.
My lord, I have started the copy now.
Mr. Goswami has already served the copy on the counsel for the petitioner. So, learned counsel for the petitioner prays for 2 weeks' time to complete his instructions and file necessary rejoinder if so advised. List again after 2 weeks.
After 20,
Yes, Mr. Burwan.
may I please your lordship, there is two petitions here. What happened, my lord? First case we have filed, that is 4/9/2025. There is an order, that is judgment in PIL 2010 itself. But that PIL has not complied. No instruction has been, about instruction is there. Second case has come up. Fact is, my lord, lordship, his lordship only this ordered, last order, it is 6/11/2024. Facts have been revealed here. May I read, my lord?
Yes.
Because here it is addressed. The genesis of both the petition, that is 6/11/2024, my lord, passed in WBC number 313/2021, my lord. Lordship got.
Yes.
The genesis of the body petition is traceable to a judgment and order dated 16/2/2010, passed in PL number 6/2007, Sri Uday Shankar Hazarika versus the State of Assam and others, wherein the petition and WBC number 4925220 was the respondent number 7. The subject matter of the POL was few contiguous parcels of land which is stated to be natural water body known as Satayan. It was stated therein that the water body constituted of railway, reserve lands, government caste lands, periodic patta lands, annual patta lands. In the PL, the Chief Conservator of Forest, Wildlife, and the Commissioner and Secretary to the Government of Assam, Forest Department in their respective cabinet had taken a stand to protect and conserve this ecosystem of this site, Chatajan, and it was awarded that it would be desirable that fishing in this site should be prohibited by law and the same to be considered into bird sanctuary community reserve under provisions of Section 36 of Wildlife Protection Act 1972. The PIL was disposed of with the following direction. Paragraph 10 of that PIL, judgment.
Who's for the forest department?
Forest department, the last occasion also not appeared, previously also not appeared. Here the question is coming only, my lord, whether this lordship is order clearly says to take decision that PIL interested taking you, whether you go for reserve or anything you do, you take decision thereafter. But without taking any decision, they have issued requisition, not acquisition, it is requisition to the.
But you have not arrayed forest as a party here in the.
No, that case, first case it is there.
Not
First-
here,
First case it is there.
but not in this.
This case it is the separate thing. This case is for requisition. By name I was given requisition. Challenging because without taking decision, requisition was made. If not even acquisition. That procedure, if requisition also.
Requisition of your
My patta land.
patta land.
My prayer was very humble and simple. This one prayer before your lordship that if they take decision for forest or any other things they want to take, this land is to be acquired, not to be.
No, but if it is a forest land.
No, not forest land. This is a
then
periodic.
there is
This is a not
of
forest
extent.
land, my lord. This is a periodic patta land also is there.
Hmm.
This is why our lordship may fix because it is hearing will be required. May I pray for fixing date of hearing date? Any date, my lord?
Yes.
17th or 16th, my lord.
Lordship, after vacation can be fixed, we have a fresh set of instruction we would.
Wait, you are not even a party. How have you got your instructions?
Second case. First case it was there, my lord.
In the second matter.
First case, 4925
We are dealing with 313.
Both the cases, both are coming together.
But 313 forest is not a party.
Not there, because not required in that case. Because there is matter pertaining to
So
requisition.
who's for the revenue department? What is your stand here?
Yes.
The last occasion, Lordship, instruction was sought from the government advocate, Lordship, regarding the conversion of landlord.
Yes.
some more time required, Lordship. We have received a letter from District Commissioner North Lakhimpur praying for some more time,
All
Lordship.
right, MSS Purva, that it brings other time. Revenue department. Three Purva.
What decade?
Three Purva and two Purva. Let the matter be listed again in the first week of February.
May I? Because this matter is very old actually. It is
Very-
from 2007 onwards running entire matter.
This is 35,
First week of-
36. 36.
That is Milord.
Right, yeah.
May I pay for first week of January? Because matter is running from 2007.
First week of January.
I just Milord. Or if not, second week. I pray for at least in January, Milord. Lordship convenience.
We have.
In the second writ petition, the forest is a party.
Yes, Milord.
So, second writ petition, you write to Mr. A. Bodhapur. High Bodhapur appears for the forest department. And then there is a fishery also.
No, that part is not required here, Jerry,
Let
because
the
that it is our intention was there.
File
No,
the affidavit.
not required.
Matter be listed. The second week of January.
Might
On a date to be fixed. with the registry.
Hearing date may be fixed
Lordship.
because it is entire matter is over otherwise.
Instruction that record not traced out. So kindly fix it last of January, Lordship, 28 or 20.
He is aware that there are
Yes,
no
you are
records.
taking-
Therefore, he wants an early date for here.
Yes. Date fixed, my lord.
All right, third week of January.
Yes, Lordship.
Third week of January.
Date, my lord, we can pay. Hearing day, my lord.
Date.
That be better.
We don't want to give you a date. Let it be in the week beginning from 20 January. So it will come in any date.
Hearing date, maybe fixed on hearing date.
We'll see about that. We'll see. Let the respond.
This response will not come, my lord.
Yes.
Oblige.
Yes.
May I please, Your Lordship?
Yes.
My lord, this proceeding, my lord, of participants in this case, my lord, demarcation, Lordship may kindly come to page 28. My lord, demarcation proceeding was initiated by the authority on the prayer of the petitioner. That, my lord, yet to be finalized, my lord. On the last occasion, Mr. Burua pays for time for obtaining instruction, my lord.
Yes.
As Burua, actually, as Burua.
Some more time
MSS
required,
Purva
Lordship.
prays for further time. It's the matter after 3 weeks. Mr. J. Sardar gives representation. Demarcation has been carried out.
But, my lord, notice has been issued, my lord, Lordship.
Where is that notice?
That 28, page 28, my lord.
28.
Circle officer, Dispute Revenue Circle has already issued notice, my lord. Demarcation case number 60/2019.
Pendency of the writ petition shall not be a bar for the demarcation to be carried. This is in 2019.
My lord. Yet not finalized.
Why demarcation not carried out? By which circle officer?
Dispute Revenue Circle, my lord.
Get it. By 17th. List on 17th December. Respondents will obtain instructions as to the status of the demarcation December. To as to why the demarcation as per the notice issued was not carried out.
Obliged, my lord.
Yes.
Lordship, notice was issued in this case, Your Lordship.
Lordship, as I was instructed by my senior, the instruction haven't received it. Kindly grant for that.
Who is your senior?
Dr. B.N. Gogoi.
Oh,
41 are happening, right? 19. DN Gogoi.
counsel for the respondent prays for further time. Mr.
SK Shah on behalf of.
S.K. Saha appears on behalf of the petitioner. Matter be listed after 3 weeks.
Interim is there, Lord.
Enabling them to complete their instructions, interim order, if any, will continue.
Deeply obliged.
Lordship, matter may be fixed on 16, similar matter fixed on 16 December,
It is submitted, which number, item number, what is the case number?
14.
Case number. Counsel for the petitioner submits that similar petition is being listed on 14th.
16 December,
16
item
December.
14, 6469.
Being WPC 64
69.
69 of 2024.
And
Therefore, the writ petition will be listed on 16th of December. Yes. None appears for the petitioner. Mr. Deborah appears for NHIDC.
Respond number 2 and 3.
Respondents number 2 and 3.
2 and 3.
2 and 3, yes.
Respondent number 1, I'm for B Deca.
MS so it is for respondent number 1.
1.
I'm sorry, my lord, I appear for the petitioner, my lord.
Yes. Yes.
Yes. May it please, my lord. My lord, we had challenged the notice dated, my lord, at page 68, my lord, annexure 5, my lord.
Yes.
My lord, we have
Page number?
Page number 68, my lord, 68 of the restriction.
Yes.
We have already been evicted from the said piece of land, my lord. Wherein pursuant to this. And my lord, subsequently, one more notice was served upon us, my lord, on 8/11, my lord. For eviction, my lord. That is under the Traffic Act, my lord.
Where is that notice?
My lord, it is a part of the record. On the last occasion, I had submitted it before the Honorable Court.
Okay.
I had got it during the course of the day when the matter was taken up. And that has been reflected by this Honorable Court in the last order as well.
All right. 8/11. Yes.
8/11.
Yes.
My lord, as per the last order, my lord, we were given the liberty from this Honorable Court to prefer a representation under section 26, subsection 3 of the Traffic Act, my lord. And we had accordingly submitted a representation before the authorities. My lord, right now, we are also not aware about the status of the said representation, my lord. Although we had preferred it.
Before the NHIDCA.
My lord, no, that is before the respondent number, my lord. No, edition of it. My lord, that is before the respondent number 3, General Manager P, National Highway and Infrastructure Development Corporation, Bongai.
Heard Mr. P.R. Sharma responded to it. Pursuant to the earlier order dated 8/11/2024, and as per the liberty granted, the preferred representation under section 26 of the Control of National Highways within bracket Land and Traffic bracket close Act 2002. Stop. They have not been served with any orders that may have been passed by the concerned authorities. Mr. Deborah, representing respondent 3, will obtain instructions in the matter and place it before the court on the next date in January.
January.
Let the matter be listed on 24th of January.
Deeply obliged.
Obliged.
Kindly have the letter dated page number 15. 15 of the paper book. Page 15. This is the notice, Your Lordship, given by the.
We can't see you properly. First adjust your camera and then address the court. We can't see you properly. What is the problem in getting it properly adjusted?
Your Lordship, then kindly fix on 13th, Your Lordship.
No, we can't see you properly, Mr. Counsel.
Yes, Your Lordship, I understand
So
you.
first rectify that. First rectify it properly.
Your Lordship, now I am audible.
No, you are visible from the reverse side.
There is some technical problem, Your Lordship.
So you are occupying railway land.
No, I am not occupying, Your Lordship. We are the lease licensee and we have given a letter of request.
Lease license pursuant to a lease executed.
Lease executed, Your Lordship.
Where is that lease?
Your Lordship, it is at page number 40. The copy sent by them, annexure number 2. Page number, it begins with page number 39, 40, the relevant part as 39.
Yes.
40, Your Lordship. May I read? Para 20. The government shall be entitled at any stage to give notice to the licensee of its intention to resume possession of the land, and subject to the proviso hereinafter contained, the licensee shall vacate the land, remove all materials and buildings belonging to the licensee, and restore the land to its original state within 30 days after the date of such notice, and the government shall not be responsible for any inconvenience, loss, and so and so. In regard to this notice, Your Lordship, they have served at 6th November, Your Lordship, to us, and we have given a representation to them that we will vacate, but they have they should give some time to vacate us, Your Lordship. For this regard, Your Lordship, I have given a letter of request. Kindly have at page number 99. Page number 99, Your Lordship. Kindly have. Page number 99. Annexure 8. May I read? To the State Officer, NF Railway. With due respect, it is humbly prayed that Your Highness may be pleased to consider the request of applicants, plot number so and so, who have been given their respective plots for shop for their livelihood by the railway authority since 1970 onwards, after receiving regular license fee in the nature of temporary occupation. This said temporary occupation is now become a means of their livelihood for last before 4 decades, and all family members are dependent upon them. They are earning. The social, educational, financial circumstances are fully covered by this business. They have no any other alternate source of livelihood. The applicants are making prayer for accepting the license fee from each of the applicants for new location, and to extend the agreement enable the applicant to complete this shifting work forthwith and granting a reasonable time of
No,
about
the,
6 months.
the lease agreement has a clause that they can take the property at any time. You will be asked to vacate. So what is the
Yes,
problem?
yes, your lordship. But your
There
lordship,
is a
the certain
of the apex
apex
court.
court judgment for their
Lordship, squarely covered, Lordship.
Where is that decision of the apex court?
This is Lordship order. And lease agreement was only for 1 year, Lordship.
No, not at all, your lordship. They have deposited the license fee.
No, there is another order.
They have deposited the license fees, your lordship, up to 2024, May 2024, your lordship. And I
Up
have
to-
annexed all the
Up to
license
which
fees.
month? Up to which month?
Up to, your lordship, May
So
2024.
May has already expired.
Yes, your lordship. And
Then-
thereafter, they have again they have charged for the November. They have also paid for the November, your lordship.
You will get back your money. But to
Your
say
lordship.
that you have a claim over the land,
No.
in
It is
spite
not,
of the agreement.
your lordship, it is not the matter of the claimants that they need the land. Only they need some time to vacate, your lordship.
How much
Only
time?
how much
How
time?
much time?
Your lordship, 2 months only.
2 months time.
Yes,
Yes,
sir,
2 months time.
Lordship,
2
already
months
notice
time.
was issued on October, Lordship. 1 month's time was granted.
No, your lordship. In November,
You'll get time up to 15 December.
No, your lordship, it is a short time, your lordship. Kindly
So
15 January.
Can't be helped.
Your lordship, because there is the order of the Supreme Court for 2 months, your lordship, in the Deepak Gupta case, your lordship.
There
Deepak
are other
Gupta
orders of the Supreme Court where it says that you have no claim over this property.
No, but your lordship, 27 December, the Honorable Supreme Court has fixed for the vacation for the other matters, your lordship. So I need only because they have given the notice in the month of October, and it is the, your lordship, for only I need 15 January, your lordship. And we will give undertaking if your lordship may fix some date for the undertaking. 15 January, your
The
lordship.
Supreme Court has granted you time till 27th December.
20 in another matter where the
That's right.
notices has where the
That's
notices
right.
has been, your lordship, where the notices has been served in the month of August, and they have given in on 6th, your lordship, November.
No.
Your lordship, kindly grant only my humble submission, and we will
Yes,
vacate,
you give a date when you want to vacate the premises. Tell us.
your lordship, 15 January.
15?
5th January, your lordship.
Is it agreeable to you?
For the, your lordship, interest of the poor persons.
Because this land is required under the Arbitrator.
Yes. There is no problem because they are the poor person. They have to ship their all the articles, and they 15th, your lordship. My humble request.
We are asking you a pointed query. Is 15 January
But-
agreeable to you or not?
We don't have instruction of our lordship whether it may be extended or not. Because on 28th, then the 1 month's notice was given.
When?
No.
Where is the
6
notice?
November.
Where is the notice?
6 November, your lordship. Because kindly have the notice.
15 onward.
No. At page number, your lordship, 15. 28th October 2024, they have given on 6th, your lordship, 6/11. The copy of the receiving of the applicant
This
number
is
1.
on 28th of October.
28th.
But they have served on the 6th, your lordship, 6 November. It has been admitted. Your lordship, kindly have page number 27. The received on 6 at 1 p.m.
What are you carrying on in this particular
My
plot
lord.
of land?
We are putting out stalls, and we are selling other articles because 1970s since, your lordship. So it is not clear from our side, but they are doing their business and livelihood, your lordship, for last 4 decades. That's why only my humble request that on 15 January we will vacate it. And they have served the notice on 6 November. In earlier cases, in the month of August, your lordship. For that sake, it was fixed for the 27th December. In pursuance of my letter of request, your lordship may, my second, we have already undertaken, your lordship, page number 99, the applicant has folded and request to your highness may be pleased to accept this license and may be pleased to grant reasonable time. So up to 20, your lordship. In pursuance of their own agreement, we are ready to vacate. There is no objection from the side of the applicant. Only I need 15 up to 15 January, your lordship.
Where is that agreement again? Page number?
Now, page number, your lordship, a moment, page number.
Page number 39 onward, Lord.
39 it begins with. Page 39 to page 40B.
This of 1970,
One.
and it was only for 1 year. It was renewed.
And continuously they have extended, your lordship. Otherwise, why they will accept the license fees?
Renewed, lordship.
They have accepted the license fees regularly.
After 24 March, lordship, license fee is not accepted.
No. In the up to the month of November, they have accepted, your lordship.
Where are the receipts?
Receipts collectively, your lordship, I have filed page number 54 to page number a bunch of your lordship, page number 86, page number 93 up to.
Till March 24, lordship.
These are all up to March 23.
24.
No, your lordship, 24, your lordship, and thereafter they have accepted for now.
Show us a specific receipt.
My lord,
Page
for
number?
that page number, your lordship, it begins with page number 54.
54
Because
is a
there
type
are
54 is a typed copy. Where is the original?
yes, your lordship, it has been
Up to March 2024.
page number 75, your lordship. Page number 75. It begins with 2003 to continuation, your lordship. May permit, I will show on 13th, your lordship. I want to physically present there. If your lordship
your last receipt is at page 55. It is for a period from April 23 to March 2024.
After that, they have also received, your lordship, but it could not be due to the short time of this preparation, your lordship. It could not be annexed with this.
How is it a short time from March 2024? You are sitting there without
No,
paying
your
any
lordship.
rent.
We have already paid up to the November, your lordship. It will be bring also on 13th. I will bring it, your lordship. My humble submission that they are ready to vacate, your lordship, fix some time. On 15 January, your lordship.
No, you come up with this. We'll
13th, your lordship.
orders.
Your lordship, 13th.
Not 13th, 11th or 12th. You pick your date.
Your lordship, I am at your lordship, Allahabad, your lordship, for that sake, because 12th and 13th are fixed there, your lordship, in two matters. At
Then you come on 16th.
Your lordship. Okay.
16th. List this matter on 16th.
Deeply obliged.
As submitted by the learned counsel for the petition. MS R. AVAPS for the respondent. Yes.
Deeply.
Well, here the government was to file the affidavit. Your lordship kindly come to the order dated 24/9/2024. Going by the last. An ultimate paragraph, in view of the aforesaid submission and the council opinion of this court, an erisa affidavit should be filed bringing the aforesaid fact on record by any of the respondents, including the Septem, whether any proposal for the de-reservation of the aforesaid plot of land had already made, has admitted the land in question within the Guwahati city and many settlements have been made over the busier land. Mother, here already settlement of mother de-reservation process was initiated far back in 1994. Your lordship will find that from my reply affidavit, page 72, annex M. Annex M. Has your lordship got my lord?
What was the last order?
Last order 24/9/2024, my lord, the government was to file affidavit on the process of the reservation, whether any action was taken in that. on that.
Any affidavit filed?
No, not yet, my lord. I didn't get a copy of it. Whether it is filed.
Previously, one affidavit was filed.
Huh?
Previously, one affidavit is record of it
Yes.
filed by government advocate. And, in that affidavit.
By the district commissioner?
Yes.
Yes.
That affidavit, lordship, lordship may peruse annex B, page 63, running page number. On that affidavit, lordship, one.
No. Thereafter, there is another order.
On that annex, lordship, I have to obtain instruction, lordship. Already, I have communicated with the department, lordship. That proposal is pending.
Which proposal?
Lordship, lordship may peruse, page number 63. Annex B of the affidavit filed by
Communication dated 13/8.
13/8/2024, lordship. In this regard, lordship, I have received one communication that our department needs more 4 weeks time, lordship.
Because your lordship kindly come to annex M, page 72 in my reply. There was initiated way back in 1994. Annex M, page 72. In pursuance to that, this order 24/9/2024 was passed by this court to bring to the notice and the record of the court what initiative is taken present. Has your lordship got my lord? 72 case.
Yes, 1 minute.
And I've also annexed the Central Tribunal Police Commissariat. Now DC office, everything has come in near my house there. Except my land, 1 kata 10 less size yet is go reserve. Ramakrishna Mission.
No communication has been received as yet.
Lordship, I have received one communication, lordship.
No, on the proposal. On
No,
the
lordship.
proposal, nothing.
They need, lordship, our department needs only.
There is some proposal which is pending.
Your lordship kindly come to page 72. This letter will clarify.
Yes.
Has your lordship got? May I read? It was written by the government of Assam to the Deputy Commissioner Kamrup, settlement of Viziar land to 41 families of the village Ulubari and Ulubari Mauza. Your letter number so. In inviting a reference to your letter on the subject cited above, I am directed to request you to kindly furnish the reservation for proceeding on completion of the VGR and land in dag number 175. Now there are many dags out of that. Ulvari village under Ulvari Mauza youth following 41 families showing the area proposed against their names for consideration of the proposal for settlement of the land submitted by you. Now my name in the list stands in my page 23, serial number 23. That's sorry, 33. Next page, page 73. Subodh Singh, 1 quarter 10 lesson. 7 less was incurred by somebody, my lord. There is a decree against that.
Now, in view of the apex court judgment,
Yeah.
you tell us where is the, is there a proposal by the state for accommodating you elsewhere? What is the proposal of the state?
That's why they have to file everything.
Worship, this land at least cannot be reserved.
So you'll have to give them some other land.
They will also kindly come to my photographs. If they can settle it with the police commissioner, page number 81 onwards. Page number 81. Photograph bila, you will office center. Reply this one. Central Administrative Tribunal officers, court has come out there. Then my lord, Arunachal Bhavan has come out there. Same dag number, 125. Then my lord, police reserve has, police commissioner has come there. Building has been constructed, it is operated. Then my lord, Assam State Human Rights Commission has come out there.
No, these are what land?
Same plot, 175.
Huh?
What they call it, go reserve, same land.
How do you say that?
Yes, 175 from 175, my dag number is 175. Now it is 401. Yes. Ongoing construction of district commissioner office, DC office now.
No. How do you say that these, your land and this land are on the same
Same man, when
category?
let them deny my lord. Let them file agreement, this way it is no.
They've
In the
come-
meantime, my lord, out of that, my lord, one dag bifurcated from 175, 1787 has also been given patta to one Ranu Bora in 2020. Patta last updated 10 to 2022, page 80. Let them say these buildings, all these government buildings and organization, Ramakrishna Mission, even private buildings are different dags away from the area. Just behind the Aurobindo school, your lordship might have seen the Aurobindo school, Aurobindo Higher Secondary School, near the PW office, after the police, DGP office. Kirki, my lord, I agree the marketing board is also there.
But they have admitted that it is the same class of land, page number 59. This is affidavit. Dag number 175 and 401.
Yes.
Classified as Go Reserve VGR.
Yes. 175 is a very big area, my lord, where all these buildings have come up. And private settlements are there, houses there. That's why government asked the DC then 1994 to initiate the proceeding for de-reservation because
Mr. Talukdar, I think you should get more clarification.
Whether these land.
No, your statement in paragraph 11 of the,
Yes.
by the DC
Yes. 11. Yes,
How can you file an affidavit like that?
a report from the circle officer says that it is, it's that part of the land is go reserve.
Right, then come to the sub-para of that paragraph.
Department also begs to refer clause 6(1) of the Assam wherein it is stated that the deputy commissioner shall make necessary endeavor to preserve existing BGR and PGR for use by the members of the public for the purpose of which these were constituted and encroachment of BGR and PGR, if any, will be removed. Henceforth, the land in BGR will not be further decreased by a reservation and allotment exam. So after that judgment, my lord, in Jogpal Singh's case, my lord, that BGR cannot be deleted.
So if it cannot be done, then why we allotted it to the other?
That instruction, of course, I do not have to.
Yeah, it is already admitted that it's part of the same land.
Yes. That we'll have to verify that, whether these building falls within the same part.
Unless, no, it is there, page 59, they have admitted, it's the same plot of land,
Same plot.
same class of land. Unless you say that these were done well prior to the judgment of the effect court.
59 doesn't, 59, my lord, doesn't say. 59.
Internal page 6 of the
Yes, ma'am.
affidavit. You have
That
to
was
find
earlier.
out,
My lord.
if these are on the same plot of land, whether these conversions, if at all, were done for allotment to other government
After
departments.
that Supreme Apex Court judgment.
Before, after, how
Yeah.
it was done, what orders were passed.
That we'll have to clarify.
So you have to clarify on that.
My lord.
DC can't file a report like this, affidavit like that. He is the DC Kamrup Metro.
Yes, my lord.
How can an affidavit like this be filed?
It doesn't say anything about these buildings, my lord.
No, it doesn't. But there is no denial that the
That petitioner had constructed a residential.
No, this is a reply with regard to para 15.
15.
This fact that the other offices are also on the same land.
175 bigger dag, now bifurcated to.
Where is your averment to that? Where is your statement in the writ petition?
In my lord, reply.
Reply affidavit,
Yes.
not in the writ petition.
Represent in those, at that time, my lord, the repression filed. I have acquired the photographs and other things
Mr.
subsequently.
R.P. Sharma, learned senior counsel, assisted by Mr. P.
My lord, there are hundreds of settlements in line.
And,
Big road has gone in nearby.
MS
Four-lane road.
G. Hazarika appearing for respondent number 1,
1, 2, 3, and 4.
1, 2, 3, and 4.
And 5.
Mr. B.J. Talukdar, senior counsel, assisted by Mr. P.K. Mehdi, appearing for respondent number 5, 6, 7, 8,
And 9.
9. Stop. The petitioner has filed a reply affidavit enclosing certain photographs and also a reply affidavit making an averment and supported by certain photographs that the area which is claimed to be considered within quotes Go Reserve and in which the petitioner has constructed his dwelling house has land measuring approximately 89 bighas. Stop. He submits. It is stated in the affidavit that uh,
Lordship, kindly report to the
submitted that there are several government and semi-government offices which have been constructed.
Even private establishments,
eh,
private
eh,
organization.
Besides private construction, in the plots of land covered by the dark number
175. Old
One-
Agdamar.
175
old.
175 old. What is the new?
Newer many man. Newer man. Mine is newer 401.
Learned counsel, senior counsel for the petitioner submits that if this land is indeed reserved for within quotes go reserve, then the government has to explain as to how this land was de-reserved for the purposes of construction of all these buildings and offices as are shown with photographs in the additional affidavit. Para. Mr. Talukdar, learned senior counsel appearing for the respondent so and so, so and so, so and so, submits that he would like to complete his instructions uh, and file necessary affidavit in response to the additional affidavit, if so advised. Let it be listed after 4 weeks. 4 weeks?
If I even brag up and they have said it was approved in my favor by the government.
Let's see what instructions come.
55.
Yes.
This matter relates to lordship settlement of land lordship. In fact, this is the second round of repetition lordship. Earlier lordship, your lordship has passed an order dated lordship annexer to 9/5/2022 lordship.
Just one minute. Hold on. Okay. Just come back in 1 minute.
Lordship.
Yes.
Lordship, page 25 lordship. This is the direction of this lordship lord. It's second paragraph lordship. May I read lordship? Upon hearing the learned counsel for the parties and upon due perusal of the proceedings on record, this court is of the view that ends of justice will be served if the Deputy Commissioner Hailakandi is directed to dispose of the representation filed by the petitioner within a time-bound manner. The Deputy Commissioner Hailakandi may call for such records as required and will also provide adequate opportunity of hearing to the petitioner and thereafter pass speaking order, taking into consideration the scheme of land settlement under a land policy 2019 notified by the government of Assam. The petitioner will furnish a copy of this order along with a writ petition with annexures before the DC Hailakandi. Pursuant thereto, the DC Hailakandi will carry out the orders of his court as directed within a period of 2 months from the date of receipt of the certified copy of the order. Thereafter, Lordship, the DC has called for various reports from the different authorities and finally passed the order. This is Lordship 19th of September 2023. That is an annexure 6, page 33, Lordship.
Next slide.
You will kindly have a look at page 34, Lordship.
Yes.
The fourth paragraph, Lordship. The circle officer and assistant settlement officer, Hailakandi Revenue Circle, in her report, by so dated 28/7/2023, also stated that as per land policy 2019, para 1.7, explanation 2, Babul Ahmed Sodial so and so has no land in his name as per office record under so and so, but an agricultural land measuring so and so has 2 bigha 8 katha has been found under his father's name, late so and so. Therefore, our office cannot declare Babul Ahmed Sodial as landless, keeping in mind the land policy 2019 definition of landless person, Lordship. And before that, Lordship, first paragraph, Lordship, page 34. Further seen and peruse the report submitted by the sub-registrar Hailakandi, sub-registrar Katlisera, by letter dated so and so, dated so and so, in connection with landed property owned by Babul Ahmed Sodial, by way of registration, wherein it is said that no such land is found registered in the name of Babul Ahmed Sodial as per record. So there is no land as per record in the name of the petitioner, Lordship. However, Lordship, in wrong appreciation of all these reports, Lordship, he has passed the order that observation and decisions are page 35, Lordship. Last paragraph.
Yes.
Babul Ahmed Sodial, so and so, is not a landless person in pursuance of land policy 2019 due to the following reasons. 1. On perusal of the report submitted by the circle officer and assistant settlement officer Hailakandi Revenue Circle, dated so and so, it is crystal clear that Babul Ahmed Sodial is not a landless person, as there is an agricultural land measuring 2 bigha 8 katha 08 chatak found under his father's name. Under so and so that. Secondly, also seen the and peruse the report submitted by the assistant director in charge food civil supplies and CA Hailakandi, dated so and so, which stated that Babul Ahmed Sodial is an fair price shop dealer under Kupa GPSS Limited, and he is receiving an average monthly commission from NFSA rice amounting to rupees 4,000 to 5,000 per month as per allotment, which clearly shows he is not a cultivator. Babul Ahmed Sodial is not a landless person in pursuance of the policy 2019. He cannot be allotted a plot of land covered by so and so. But they have submitted a affidavit in opposition, Lordship. And wherein, my Lord, kindly have a look at the report. Page 60, Annexer D. On the basis of this report, Lordship, the Deputy Commissioner passed the order, Lordship.
It's 28th of July.
Lordship, 2020.
Yes.
With reference to the subject cited above, I have the honor to inform you that during inquiry, it is seen that so and so after date of alleged Sangul Mia Sodial, father of Babul Ahmed Sodial, the above mentioned land is recorded as Asmali, OCRR, by right of inheritance as per mutation dated 23/3/1987 in the name of Nur Ahmed Sodial, Ainul Haq Sodial, Rusna Begum Sodial, Akirun Nessa Sodial as a descendant. Here in my Lord, the name of the petitioner is not here, Lord. During an inquiry, it is also found that as per NOK certificate issued by the GP office Narayanpur, 1 Babul Ahmed Sodial, Nur Ahmed Sodial, Ainul Haq Sodial, Moinul Haq Sodial, Sarimul Haq Sodial, Akirun Nessa Sodial, Rusna Begum Sodial, Sajna Begum Sodial, Sultana Begum Sodial names are mentioned as descendant of late Sungul Mia Sodial. But during mutation dated 23/3/1987, descendant of late Sangul Mia Sodial, namely Babul Ahmed Sodial, Moinul Haq Sodial, Sarimul Haq Sodial, Sajna Begum Sodial, Sultana Begum Sodial, out of his 9 descendants are not recorded at the time. it may be noted that as per Land Policy Act 2019, para 1.7, explanation 2, Babul Ahmed Sodial, son of so have no land in his name as per office record under 92 so but an agricultural land measuring 2 bigha 8 shatak have been found under his father's name, late Sungul Mia Sodial. Therefore, this office cannot declare Babul Ahmed Sodial as landless, keeping in mind of the Land Policy Act 2019. And this report clearly speaks that, my lord, the petitioner has no land, lordship, in his name.
No land, but agricultural land standing in the name of his father.
His father, but my lord, it is 2 bigha, 8 kotha and 2 shatak.
So it is beyond the limitation, beyond the limit prescribed under explanation 2.
My lord, kindly have a look at the explanation 2. They have annexed page 61, lordship.
Yes.
Kindly have a look at explanation 1, lordship.
Yes.
Explanation 1. Rural area shall mean the area beyond 15 kilometers from the so-and-so. And this agriculture includes horticulture, so-and-so. Explanation 2. A person who has agricultural land to the extent of 1 bigha or less in his name or in the name of his family, either as tenant or as an owner, anywhere in the state of Assam, and has no means of livelihood other than cultivation, will be regarded as a landless person for the purpose of entitlement for getting settlement of land for agricultural purpose. And the explanation regarding the family, lordship. This is explanation. Family means a family consisting of one or more of the following, namely one husband, 2 wife, 3 minor children, and also includes a joint family. Joint family means family of which the members are descendants from a common ancestor and have a common mass, and shall include wife or husband as the case may be, but shall exclude married daughters, married sons, and their children, provided that a family consisting of father and or mother, sons, and or unmarried daughters holding lands jointly shall be presumed to be joint in spite of having a separate marriage. Remember, the petitioner has been living separately, lordship, and he's not living in the common mass, lordship. And another aspect is that lordship, the total land which was in the name of the father of the petitioner is 2 bigha, lordship, and it has been mutated almost with 4 persons, lordship. And it will be less than 1 bigha, lordship.
No, but it is not in your name.
No, it is not in my name, lordship. And then I am covered under explanation 2 and the joint family, lordship.
No, joint family, there has to be a finding on that. I mean, how does one find out whether you're living there or elsewhere?
Because I am living in the present place wherein I have applied for the settlement, lordship. And I have also categorical statement in my writ petition also, lordship, that I am living in a separate match.
Yes, Mr.
No, that we will not be costly matter. We will not be covered by explanation 2 because lordship will see that a person who has agricultural land to the extent of 1 bigha or less, or in the name of his family, either as tenant or owner, anywhere in the state of Assam, and has no means of livelihood other than cultivation, he is a fair price shop also. That in our affidavit we have stated, and hearing was also given to him, according to him, my lord. Paragraph 6 of our affidavit, we have stated in detail. Second affidavit, my lord, which was filed on.
You are employed, you have a fair price shop.
Lordship.
Then how does it make you landless? So this no means of livelihood is also one of the conditions.
One of the conditions.
Other than cultivation.
Okay. And then a question arises, here it reflects that who has agricultural land to the extent of 1 bigha or less, and lordship has no means of livelihood. Herein, my lord, I have no land, lordship. It's an admitted position, lordship.
No. 1 bigha of land or less.
Less, lordship.
Up to 1 bigha.
Lordship.
Even if you have, will not be considered to be land.
Lordship.
So that is as good as saying that you have no land.
Lordship.
But you'll have to satisfy the other condition, no means of livelihood,
But Lord,
which you don't fulfill.
Thereafter, Lord, kindly next paragraph, kindly have a look, lordship. Preference shall be given on next paragraph, lordship. However, anybody having more than 3.5 bihas of land, taking into account both agricultural and homestead, shall not be eligible for further settlement of government land.
Then?
Well, perhaps, my lord, it is a clear intention that 1 bigha up to 3 bigha, lord. For my understanding is concerned, lord. But my lord, if I am a totally landless person, lord, in that point, lordship, perhaps this land policy 2019 is silent, lordship.
So you may not have any land, but you have a means of livelihood other than cultivation. There is no denial of that fact.
In that case, lordship, I am entitled for a homestead land, lordship. Because I am totally landless.
Where is the land policy?
Land policy suits me, but
What are there any different classes under which you can be driven?
we are looking in rule 3, may I read, lordship, regarding allotment, settlement of land for homestead purpose in rural areas. Lordship.
Page number?
We are lordship, it's not a part of the three. Rule 3, Lord.
Any member of their family. Is there any appellate forum here?
Land. Nine. I don't think.
This is 989. 9.
One more thing to submit, lordship, is that the fair price stop is the temporary one, lordship. From my understanding, is concerned, lordship. At any point of time, my lord, the license may be cancelled, lordship.
This is the rule.
Lordship.
Either you interpret it or challenge it.
Lordship.
We can't change the rule because you address the court that there is an exception under which you can be considered.
And regarding homestead land, lordship, Family lordship, then the explanation will come regarding family lordship. Family means joint family, not is not included under the definition of that family lordship.
You want to say that this aspect was not examined?
Lordship.
What do you say?
My lord, that part, my lord, in paragraph 6 of our affidavit, second affidavit, which was filed on November 4th November 2024.
There are six.
Para 6. Names.
Yes.
With regard to statement made in paragraph 2 of the in the answering department, humbly submit.
One minute, one. This is, sorry, the reply. Page 47.
49. Page 49.
Para 8.
6.
Para 6.
Page 45.
This is by additional district commissioner.
This is by district.
Yes.
District commission.
Huh?
Gautam
What is the name of the person?
Nisar Gautam Dibari. District commission.
One is filed by Saptati
Satyavan.
Endow. This is one then.
One is filed by Endow. But this is by second, it was filed pursuant to the honorable
This
court's
is the additional affidavit.
additional affidavit pursuant to the direction of the honorable court
Yes.
dated 16/9/2000.
Yes, yes.
The paragraph 6, it says, my lord, the answering department humbly submits that in compliance of honorable court's order dated 9/5/22, past in WPC number so and so. I have provided opportunity to the petitioner to be heard and recorded his statement. On the other hand, the petitioner appears on 18/6/22 at so and so in the office chamber of Srimati Mulchana Malakar, ACS, Assistant Commissioner Hailakandi, who recorded his statement and submitted her report on 27/7/2022 with reference to the then additional commissioner so and so dated 10/6/22. In her report dated 27/7/22, Srimati Malakar stated that as per statement of the petitioner, he has been possessing land measuring 4 biga 18 katha at Moja so and so part 3, which is central khas, and land measuring 1 biga is the parental land, including his co-sharer. The petitioner also stated that he is a fair price shop dealer. The report dated 27/7/22 reflects that other than the central khas land, the petitioner has been possessing land in Patta number 17, Dag number 37 of Moja so and so, and part of which was acquired during the construction of Hailakandi bypass of NH 54. And the petitioner received land compensation of rupees so and so and Jirat compensation, including building valued at rupees 8 lakh something, and additional Jirat compensation of rupees so and so. And in the said report, it was suggested to collect report from the circle officer and assistant circle officer so and so, revenue circle, whether the petitioner family has land in Moja so and so, to ensure the category of the petitioner whether land is or not. Apart from this current minor property, he also was occupying government khas land, and a part of the and another portion of the land which was under his possession, my lord, he was paid compensation, zero compensation. My lord.
Pursuant to this, there was an inquiry also by the circle officer.
No, sir, I'll come.
What do you say about this explanation? Explanation 2, last subparagraph, page number 61 in land policy. There it says anyone having more than 3.5 bigha of land, taking into account both agriculture and homestead, shall not be eligible. So if you,
Anybody having more than 3.5 bighas of land, taking into account of both agriculture and homestead, shall not be eligible for further settlement of more than 3 bighas. But the expression 2 is qualified by no means of livelihood other than agriculture. That has to be satisfied.
but this appears to be an exception, however.
That 3.5 figure has been amended to 7.1 lordship.
Who?
The 3.5 figure is amended lordship.
What
The
is,
3 figure shall be 7 and the half figure shall be 1 lordship. There is a notification dated 12 March
so
2020.
3.5 bigha has gone up to 7.5 bigha.
No, 3 will be 7 and half will be 1 lordship.
So
So up to
what, 8
up
bigha?
to 8 bighas they can claim. What is that?
No. Lordship, there is an amendment of I have it on the soft copy, Lordship. Lordship may peruse paragraph 1.3, Lordship, para 1.3 of land policy.
Land policy. Land policy.
The maximum limit of land for allotment to an individual is fixed at 3 bighas for agricultural and half bigha for homestead purpose. That homestead purpose, Lordship, amended to 1 bigha.
Okay,
And the 3 bigha, Lordship, amended to 7 bigha.
for agriculture.
Yes, Lordship.
So therefore, anyone who has more than 7 bigha and 1 bigha, taking into account agricultural and homestead, will not be eligible.
Lordship.
So admittedly, they don't have, assuming his father, his family has some agricultural land that will be less than 7 bigha. But you are also entitled for land compensation. You have received some share.
That was a perhaps Virat compensation, not it.
Whatever it is.
Virat compensation in respect of this land, not it.
What is that plot of land? Is it the government land that you are
Government landlord,
presently residing?
government landlord.
Are these the complete, is the complete policy? You got the complete policy, land policy,
Okay, I've downloaded it from the
with all the amendments, let us see what.
The amendment is, Lordship, there is a one notification dated 12 March 2020, Lordship, that I have been made. I have made
So you give us the
amended notification.
amended plus the original one. What about clause number 3? Is it been amended? Has it got amended?
Clause number 3, amended of para 3.1 has been, yes, Lordship.
Huh?
In para 3.1, the word half bigha after the word exceeding and before the word per family shall be substituted by 1 bigha, Lordship.
All right.
Lordship,
But otherwise, other than that, it has not been.
only that, Lordship, that half bigha become 1 bigha and 3 to 7 bigha, Lordship.
And what is the criteria for consideration under clause 3?
That will be same, Lordship. Petitioner shall be indigenous.
From where have they extracted this explanation? Page number 61. Which part of the land policy?
1.7, 1.7.
1.7, 1.7.
1.7. 1.7?
And 1.8.
1.7 is for allotment of government land for agriculture, ordinary cultivation.
Okay.
Yes. 1.8 is settlement of land for ordinary cultivation. You are asking for what? Homestead. You are asking land for what?
In the present land, Lordship, I am living.
For cultivation or for homestead?
Actually, like both cultivation and.
There are two different categories.
Lordship.
Clause 3 is for allotment of land for homestead. Where is the representation you had filed before the authority?
And it's a one, Lordship.
Page number?
Page number 19 and another is 20, page 20, 19 and 20 is two representation.
Nineteen and
Page 20, Lordship.
20. Page 20, you see, you are a poor farmer and earn your livelihood through cultivation.
No.
This is not a correct statement as per the report. This is not a correct statement. It's the wrong statement. Therefore, explanation 3 doesn't apply to you. And in view of the fact that you are already a fair price dealer, you're not entitled to, you are not cultivating on land. Therefore, you're not entitled to government land.
I'm staying in the place also, Lord.
Your application is not for that.
Lordship.
Your application is for cultivation. Therefore, we dismiss.
Besides my cultivation, Lordship, I was also.
We are going, see, you had come to the court earlier. Court had directed disposal of your representation. Pursuant to that, the order was passed. Now you are challenging that order, that it is in terms of, not in terms of the land policy. So your very application was for allotment of land for cultivation. Therefore, they said that you are not a cultivator. You have a fair price shop. You're a fair price shop dealer.
Lordship, in that land lordship, I am cultivating lordship.
You may be cultivating, that's a different issue. But you do not deny that you have a fair price shop. You do not deny that you are not earning your livelihood by cultivation. So as a cultivator, you are not entitled.
But my lord, in that representation, Lordship, I am praying for placing my matter before the subdivisional land advisory committee, Lordship.
Whatever that circle officer has rejected your proposal.
Regarding that part, Lordship, I will consider under the rule 3 of the land policy, Lordship, because my lord, besides cultivation, I was also living there, Lordship.
Rule 3 cannot be considered because your application says you want it for cultivation.
But my lord, here, Lordship, kindly look at the explanation 2, Lordship. Anybody having more than this much, both agriculture and homestead cannot be eligible for fire. Here also both are considered. However, anybody having more than, and this was amended, we have submitted.
This is not be eligible for further settlement.
Agriculture and homestead, both are considered.
But not for further settlement. Your prayer for settlement was for agricultural land. On the facts mentioned, it was rejected. You are before the court challenging that no, the explanation 3 was not considered. Explanation 3 is for homestead. You never applied for homestead.
But repeatedly, I am submitted lots in the petition also. I have mentioned that I am staying there along with calculation logic, and that part may be considered logic.
You file press representation.
Lordship.
Let them consider under explanation 3 if required for homestead.
Lordship.
We don't find any error in the order.
Lordship.
Heard Mr. R. Pupandar, Commissioner, Mr. PJ Talukar, Senior Company Assisted by Mr. PK Teka, appearing for respondent number 2, MSG, other respondent number 1. Petitioner is aggrieved by the order bearing number so and so, dated 19/9/2023, passed by District Commissioner Hailakandi. Where is that order?
Page 33, Lord. Annexure 6.
Page 33. Whereby his prayer for allotment of land was rejected on the following grounds, page 35, observation and decision extract. Stop. 35, 36. Learned counsel for the petitioner submits the finding of the authority that he had a family land, he had inherited family land belonging to his father. He is incorrect on facts as he does not have a share of the same and is living separately and carrying on his livelihood. Stop. The petitioner is also undertaking cultivation on the land that is under that on the land that is under his possession. Stop. The petitioner therefore submits that the rejection of the order by the impugned order dated so and so passed by the DC is contrary to the very land policy 2019 along with as amended up to date. He submits that even assuming, though not admitting, that he has share of the land, then also share of the family land, then also the land if it would have devolved in his name would be short of the limit prescribed under the state policy. Stop. Stop. Learned counsel for the petitioner is also referred to clause 3 of the land policy to submit that an indigenous family of the state who does not have homestead land in the name of any member of the family anywhere in the state may be allotted with suitable homestead land not exceeding 1 bigha within bracket as amended bracket 2 per family. Stop. He submits that he is entitled to be he is entitled to be considered under this provision, which however was not considered by the DC while passing the impugned order. Stop. Para Mr. P.J. Talukdar, learned counsel appearing for the respondent 2, submits that an affidavit has been filed where the report of the circle officer is enclosed. The report reflects that an agricultural land measuring 2 bigha 8 kota 8 chatak has been found under the name of the petitioner's father, and under such circumstances he cannot be considered to be a landless person, keeping in view the policy land policy 2009. Stop. That apart, the impugned the order of the DC reflects that the petitioner is not carrying his livelihood as an agriculturist, but he is a fair price shop dealer. Yes. Fair price shop dealer. Stop. These findings are not disputed by the petitioner. Stop. Under such circumstances, there is no infirmity in the order, and the writ petition should be dismissed. Para MSG Hazarika, learned counsel appearing for respondent 1, also adopts the arguments made by counsel for respondent 2. Learned counsel for the parties have been heard. Pleadings available on record are perused. Land policy 2019 has been perused. This court, by earlier order, dated 9/5/2020, passed in WPC 1264, disposed of the writ petition filed by the petitioner on the ground that his representation filed before the Deputy Commissioner seeking allotment of adequate land to enable him to earn his livelihood by cultivation of the said land was not considered. No effective order had been passed. So, under such circumstances, this court disposed of the writ petition with a direction to the DC Hailakandi to pass appropriate orders on the representation within a time-bound manner within a period of 2 months from the date of receipt of a certified copy of the order. Stop. The application, the representation filed by the petitioner is, where is your representation?
Page 19, Lordship, and 20, Annexure 1 and 1A.
Filed before the authority on 1/9/2018 as well as on 5/1/2020 is available in the writ petition. So, in the said representation dated 5/1/2020, the petitioner has prayed for placing his representation before the Land Advisory Committee for recommendation for settlement of land on the ground that he is a poor farmer and he earns his livelihood through cultivation. Stop. On these materials, the DC directed the circle officer to concerned circle officer to conduct an inquiry, and on the basis of such an inquiry, the order dated so and so impugned in the writ petition, order dated
19/9/2020.
19/9/2023 was passed by the DC Hailakandi, rejecting the claim of the writ petitioner. Stop. The claim was rejected on 2 grounds, primarily that the petitioner cannot be considered to be a landless person, as an agricultural land measuring 2 biga, 8 kota, 8 chatak was found allotted to his late father, and late father. Stop. That apart, the petitioner is found to be a fair price shop dealer under the Bhatir Kupa GPSS Limited and is receiving an average monthly commission from the NFSA rights amounting to rupees 4,000 to 5,000 per month per allotment. So, on these materials, the Deputy Commissioner Hailakandi arrived at a conclusion that the petitioner is not a cultivator. And in view of the fact that his father was, in view of the fact that land measuring 2 bigas, 8 kotas, 8 chataks is found to be standing in the name of his late father, he cannot be considered for allotment of a plot of land as a landless person under land policy of 2019. Stop. Having perused the land policy, we find that the provisions in under clause 1.7, under clause 1 is for allotment and settlement of government land for ordinary cultivation in rural area. So, the petitioner's claim under this clause 1 has to be understood in terms of clause 1.7, which provides has to be considered in terms of the explanation 2, TO2, explanation 2, figure 2, then TO2 to clause 1.7, which provides that a person who has less than 1 bigha or less of name in his family, either as a tenant or an owner, anywhere in the state of Assam, and has no means of livelihood other than cultivation, will be regarded as a landless person. So, here admittedly, the petitioner is earning his livelihood as a fair price shop dealer and not by cultivation, as is revealed in the inquiry report of the circle officer, which is relied upon by the deputy commissioner. Stop. Under such circumstances, it is clear that the petitioner does not fall under the said explanation 2. In that view of the matter, the court does not find any infirmity in the order impugned, order dated so and so, passed by the DC, Hailakandi, which is in present proceedings. However, a perusal of clause 3 of the said land policy provides for allotment or settlement of land for homestead purpose in rural area. So, the submission of the council before this court is that even the land on which he is dwelling is not allotted, and he is he is a landless person, and therefore his claim ought to have been considered under clause 3. Stop. But having perused the representation filed with the petitioner, which was disposed of by the DC Hailakandi by order dated so and so, in terms of the directions issued by the court, it is seen that the application was the application of the petitioner was only for allotment of land for agricultural purpose. So, under such circumstances, petitioner is, while disposing of this writ petition without interfering with the order passed by the DC dated so and so, petitioner is granted liberty to file proper application before the competent authority for allotment of land for homestead purposes in rural area. Stop. If any such application is filed, the authority competent to deal with it will examine the matter in the light of clause 3 of the land policy of 2019 and dispose of the said application by passing a speaking order. Stop. With the above observation, writ petition stands closed. No order is to post.
Obliged, sir.
Huh? 57 at the on the basis of the adjournment circulated matters has deferred. Adjourned. Yes.
I've got the agreement copies. Contract.
Yes. Give us the agreement. Where is the clause? Clause for arbitration?
I'm just like monkey. Like monkey. Like
Special condition है ऊपर।
नहीं, decision 37 बोला नहीं है। Next slide. Yes, you find it, we'll take it up in a while.
Not.
I'm just. Yes.
But in this case, he has already received final bill, no claim certificate has been issued, everything has been issued also.
Is it?
Yeah, that is, in my reply, I have already given reply to that.
Then
In this,
you
I
still
did,
have a dispute.
no, your lordship, they said that I have not signed the final bill without protest. So in this regard, I have, in my reply, I have given letter to G while receiving final bill on 7/8/21,
Under
where
protest.
I
Under protest.
under protest.
So, this agreement, where is that clause in the agreement?
Is on page 40, Lordship.
Page 40 of
40 of our affidavit.
your affidavit. इसको serial करके रख दीजिए.
The amended portion, Lordship.
Page 40, where is that?
Last portion, Lordship. Condition 37 arbitration. Chart of press subpara as under after the existing subpara 3. These are the actually Lordship, this is the amended portion.
All right, now there is some dispute. You have you named an arbitrator? Have you given the name of the arbitrator?
No, lordship, it is to be decided by the honorable high
All
court.
right, we are appointing an arbitrator.
Otherwise, Lordship, they have also signed a no claim certificate.
No, there is a,
Yes.
he has stated that he is accepted it under protest. Where is your notice? Where is the notice?
Yes, sir, lordship, I applied for appointment of arbitrator, and secondly,
No, where, which page? Page number?
I have given notice to them.
Where is the notice?
6 to 7 page of affidavit, my original petition.
Huh?
Page number 6 to 7, where I applied
6
for
to 7.
Yeah, appointment for arbitrator, I requested for.
A notification I will take. Heard Mr. Sanjay Sharma, petitioner in person, also heard MS Arbitration Act. Mr. MSR Devi, journalist, appearing for the respondent. The petitioner was awarded a contract by the Commander Works Engineers, Shillong, and an agreement being CWE/GUW/71 of 2017 and 18 was executed by and between the petitioner and the respondent number 2. This work was allotted to the petitioner to undertake special repair/replacement of furniture items against condemned furniture and special repair slash replacement of BER furniture under the office of the garrison engineer. One. The work was completed on 11 January 2021. And pursuant thereto, disputes had arisen between the petitioner and the respondent with regard to the amount payable. Dispute is with regard to the amount.
Compensation deducted from me, your lordship.
Why? Because of the delay.
Delay, yeah.
Dispute had arisen as the compensation amount was deducted from the final bills of the petitioner because of delay purported to have been made by the petitioner contrary to the agreement executed while completing the work. So the respondents have filed an affidavit where they have enclosed, the petitioner has filed an affidavit to enclose a communication dated 7/8/2021, where an amount of rupees 146,038 was received by the petitioner paying the payment of final bill. Stop, the said amount was received under protest. Petitioner submits that he is entitled to, where is your final bill? Total amount?
That is the amount, final bill amount, and the deduction amount of compensation was around 145 lakh, 1 lakh 45.
No, what is your total claim?
145,000, 1 lakh 45,000. That was 10% of the CA amount.
No, after doing the contract, you are entitled to raise bills.
Yeah.
What is the amount of bills you have raised?
Your lordship, the
Total amount?
Total amount was 14 lakhs 67,000 something. That is the figure.
14 lakhs odd amount was raised
67,000.
Towards completion of the work. So,
out of this 10% of this amount has been.
Council for the Railways also, as well as the petitioner in person, submit that the contract agreement contains a clause for arbitration in the event such disputes arise. So, where is that contract? Where is that clause? Arbitration? Arbitration clause?
37.
37. The arbitration clause, not 37, something else.
It's the amended portion also. Original one is.
Where is that page?
Not the 40, page 40.
As per clause 37 of the agreement, there is a provision for arbitration in the event any disputes arise. In the arbitration is to be referred to in the event the claims or counter claims exceeds rupees 1 lakh. So the petitioner in person submits that his total claim is 14 lakhs. You don't know the total amount.
As per work order value, as per petition, page number 9 was 14 lakh 67,700.
Page number?
Page number 9 of petition.
Page
That is
number
the work
9.
order is there.
It is submitted that as per the work order, page number 9.
9.
As per the work order, the total amount, contract value is 14,67,700.
Out of which 10% of this amount has been deducted as compensation, and that is the dispute point.
Out of this amount, 10% has been deducted as compensation for the delay which the respondents have attributed to the petition. Stop it. say, in view of the disputes which had arisen, the petitioner had issued a notice dated 16/8/2023, calling upon the respondents to appoint an arbitrator. Stop. The respondents having failed to appoint the arbitrator as per notice dated 16/8/2023, has the present petitioner has filed his application under section 11, praying for appointment of an arbitrator. So, learned counsels for the, have you filed any response? Where is that? What is your claim with regard to in response to the notice?
Notice lordship, since final bill has been cleared lordship and no claim certificate has been signed by the other
MS
parties.
so learned CTC,
There is no dispute lordship.
relying on the affidavit filed, submits that there is no dispute and therefore there is no occasion to refer the matter to arbitration. And consequently, the respondents did not concur on the claims made by the petitioner for appointment of an arbitrator. So,
Your Lordship, one submission is that in additional petition page number 17, addressed to CW, where I applied for extension of time or waiver of compensation. And in that reply, they said that all this, you have not signed the protest. In this regard, I cited Supreme Court order.
no, these are okay. These are not necessary. Learned counsel for the respondent submits that the petitioner's final bill has been settled. He has received that amount. Therefore, there is no dispute. Consequently, no claim for arbitration can be entertained. Learned counsel for the parties have been heard. Pleadings available on recorder heavily perused. As per the work order, the amount, as per the work order dated 15 March 2018, petitioner was awarded the work of so-and-so, page number 9, the writ petition, extract the work, where the contract value is 14,67,700. Stop. Thereafter, an agreement was executed by and between the petitioner and the respondents, which is not disputed. Stop. Because of certain delay which have occurred, according to the respondents, attributed to the petitioner, an amount of 10% was deducted from the total final bill. Stop. The final bill was received by the petitioner under protest, as is evident from communication dated 7/8/2021, which is enclosed to the additional affidavit filed with the commission. So, the arbitration clause, as is evident from the agreement, also provides that in case of any dispute exceeding the value of rupees 1 lakh, the arbitrator shall give reasons for the award. In case of any dispute, matter is to be referred to arbitration, and further, in case of the claims or counterclaims made during the reference exceeds rupees 1 lakh, the arbitrator shall give reasons for the award. The petitioner in person has also issued notice under section 21 as required under the Act, provisions of Act of 1986. It is not in dispute that the respondents have refused or has failed to respond to the notice by appointing an arbitrator, by concurring on the request for appointment of an arbitrator. So, under such circumstances, under the powers exercised under section 11(6), this court considers it appropriate, considers it an appropriate case where there is a valid arbitration agreement between the parties and disputes having been having arisen between the parties relating to the said agreement, the matter is required to be referred to arbitration. Stop. The respondents have failed to appoint an arbitrator pursuant to the notice served by the petitioner in person. So, accordingly, this court considers it appropriate to appoint you don't have a choice.
I will request the name of this M.K. Bhattacharya. Retired district judge.
M.K. Mrinmoy Kumar Bhattacharya, former district judge, district and session judge of Assam, to act as an arbitrator. Stop. The parties before the court will communicate this order to the prospective arbitrator to be appointed by the court, and the arbitrator will subject to the arbitrator expressing his willingness by way of a disclosure as is required under section 12(1), the arbitration conciliation act. So let the disclosure be placed before the court on the next date fixed, pursuant to which the order of appointment of the prospective arbitrator shall be confirmed. Let the matter be listed again on 10th of January, 9th of January, 9th of January.
Lordship, in this matter, Lordship, my matters also, Lordship, the 37, para 37 is there, Lordship. Because in the contract agreement, only the amendment portion is there, Lordship, the agreement.
So you want to say same order?
Same. And Lordship, only thing is that the 11.6 mandate of 11.6 application was not there, Lordship. Because he had made an application, we have asked him in our affidavit, we have said. Can you see, Lordship?
Where is that?
Item number 58, arbitration petition 8.
Yes.
Here, Lordship, he had said that his dispute regarding what dispute, nothing has there. Only say annexure P1, page 6, the reference, nothing is, only thing is that there is a dispute arose, appoint an arbitrator. Regarding what, nothing is there. We have, thereafter, we replied to his letter, which he say, in his reply said he doesn't receive this reply. Kindly see, Lordship, his annexure P1, page 6. There is nothing what dispute, only thing is there, and whereas according to the state contract agreement, the authority mentioned appointment of sole arbitrator in chief engineer, Shillong zone, so and so. Now, therefore, in virtue of the aforesaid, we have a request you to appoint a sole arbitrator to adjudicate a deal. What dispute, what, nothing is there. To that, Lordship, we have written a letter, reply to him. It is in annexure A of my affidavit in opposition. Reference to your letter that is so and so. In connection, kindly refer to stipulation so and so to take further action, where he had taken no action and directly come to High Court.
Annexure?
annexure, page 16 of my affidavit in opposition.
Where is that letter?
That is annexure A of our, this is reply to his letter for appointment of arbitrator.
Your letter is equally cryptic.
Lordship.
You can't
Because-
make out what you have stated in the letter.
Reference to your letter number so and so, that 31st March 23. In this connection, kindly refer the stipulation of High Court headquarters CE Air Force Shillong, letter number so and so, dated 11 April, addressed to you. That is in page 17 is there, because there is
You
an
have to
amendment.
quantify what is the dispute.
Actually, it was same as compensation was rejected
But nothing is there.
for due to delay work. And secondly, your lordship, when I applied for appointment of arbitrator, in reply to our letter, in my petition number page 8. And first of all, I want your attention to CA number, contract agreement number of these are 18 and 19, financially
There is
18
no-
and 18,
There is no
19.
dispute that you have deducted 10%. That's the only dispute. Okay. You're passing similar orders.
8, 9, 10 and all respondent are CWT number.
All right.
Chair for
Similar order,
taking.
except the contract date, work, and the amount.
In item number 10, Lordship, in item 16, their arbitrator was appointed. What he had done, Lordship, he writing a letter to the arbitrator that.
Which matter? Which matter? Item?
Item 60.
60.
60.
Yes.
Here, Lordship, arbitrator has been appointed.
We are now with 58 and 59 is over.
Over.
All right. 60.
60, Lordship, what he had done, Lordship, we have appointed an arbitrator, sole arbitrator. He writes to the arbitrator that we have filed a section 11 petition. So you, before that, Lordship, he has come to writ petition also. The writ order is annexure in my affidavit, page 18. Lordship, annexure B, page 21, Lordship, that Vinit Anand arbitrator has been appointed. What he writes, Lordship, where is the above mentioned contract agreements entered between Spencer and where is the state contract included an arbitration agreement, condition 37 of the contract forming a part of the contract which interiorly appropriates all dispute between the parties to the contract.
Page number?
Page number 21 of my affidavit in opposition. Where we have appointed an arbitrator to adjudicate upon the dispute. I'm reading page 22. We have been appointed. Now he writes a letter to the arbitrator that section 11 petition has been filed before this honorable court. So your arbitration is not required. But in terms of that, we have appointed the arbitrator. His letter. Page 25, his letter. He write to the arbitrator. Here he is not mention anything that he had. (23 to 24).
This is appointed by whom?
By our
chief engineer.
Chief engineer.
This is no longer valid in view of your full court judgment of the apex court.
That is true, Lordship, because it is 20.
He has to give a waiver. He has to agree.
He has agreed, Lordship, in the contract term, Lordship, he has agreed.
No. He has to agree to this. You have to write to him that we want to appoint. These are our panel of arbitrators.
Lordship,
He
it
has to give a waiver to say that, all right, no difficulty. Otherwise, you can't do it.
Your Lordship,
Under
here I
12.5.
want to bring some interesting point.
No,
Arbitration
do
petition.
you agree with this gentleman appointed as?
No.
You don't.
No.
Where have you stated that?
nothing is in this petition law.
Yours,
Nowhere is there.
I want your
Have you
attention to.
stated somewhere in the petition?
Nowhere.
No.
Yeah, I have given civil Supreme Court judgment that you are.
Or in the petition, have you stated somewhere that you disagree with this appointment?
Yeah, I have written the letter that is just a page number here. Your Lordship. Affidavit letter.
All right, in this petition, you write, heard same agreement. Work order issued for an amount of so and so. And dispute arose, there was a deduction of that amount for the delay. And in pursuance to the notice, where is the notice issued for appointment of arbitrator?
In I-10 lordship.
Number
Do you have it
6
here?
to 7 your place.
Huh?
In my petition 6 and 7 page.
Page 6 and 7.
6 and 7 of my original petition.
11.9. Is it 11.9 or 11.3?
11.9.23.
11.9.23, huh? Notice. Pursuant to that, the respondents by communication dated 8th of February 2024 had appointed Sri Vinit Anand, Director within bracket PM, HQ, CCE Army, number 2, Isamari, so page number 21 of the affidavit, as a sole arbitrator. Stop. Where the petitioner in person before the court seeking an appointment of arbitrator on the ground that he did not concur to the appointment, unilateral appointment of sole arbitrator made by the respondents. Such submission is disputed by the learned CGC, saying that there was no refusal on his part to disagree with the appointment made by the army officers, army authorities. So, it is no longer a syndicat that, in view of the recent constitution-based judgment rendered by the Apex Court in Central Organization for Railway Electrification, where the majority view is that appointments made from a panel by the employer cannot be considered valid unless the contractor exercises his waiver. Stop. In the present proceedings, as also submitted by the petitioner in person, that he did not consent to the appointment of the sole arbitrator made by the army authorities. So, under such circumstances, in view of the provisions of section 12(5) of the Arbitration and Conciliation Act, the appointment made by the army authority, the sole arbitrator, cannot be sustained. Accordingly, the court, having accordingly, the petition having been filed under section 11, this court is required to exercise its power under section 11(6) to appoint an arbitrator. So, the petitioner in person has suggested the name of Sri Mrinmoy Kumar Bhattacharya, former retired district and session judge of Sam, and whose name is also reflected in notification number 29 issued by the registry Under such circumstances, this court, under exercise of power under section 6, appoints so and so as the sole arbitrator to enter into arbitration to resolve the disputes between the petitioner and the respondent authorities arising out of the agreement number so and so executed by and between the petitioner and the respondents. So this appointment, however, will be subject to the declaration required to be submitted by the prospective arbitrator under section 12(1). So let the declaration be in writing, be placed before the court on 9th January. Please record.
May it please Lordship. Lordship, I am appearing on behalf of Deborah. Require some time to file affidavit in reply.
Senate counsel for the petitioner requires praise for further time to file affidavit in reply. MSS Purva appears for the respondent. Please take part. After 2 weeks. Yes, Mr. Goswami.
This matter is fixed by your lordship's judgment, my lord. Just I could not read out the whole judgment. Can it be on Friday next, my lord, on 16th, my lord? So it can be
16, all right.
16 in the motion, yeah.
So what?
Today is also motion there.
Let it be on 16.
16 January. Let it be on 16, my lord, on that month.
16, so I have some person difficult. Cannot be on 18th or 17th or
No, 16. What difficulty?
some person.
On Wednesday, then I have no difficulty, my lord, then also 13.
17.
Highly of
Let the matter be listed on 7 at the joint break.
I am appearing for 120.
MSS Burwa, PS for respondent 120. Yes.
Item 61.
Yes. 61.
2017 matter.
What is the matter about?
So in this case, their application for claiming exemption, that they are existing industry. It was rejected. They claim that they are existing industry and they're claiming benefit under close 5B A of the scheme law. It was rejected by the department. That we said that they started their commercial production from 1/8/2008. So they fall under clause A law, not under P.
Clause AO?
Scheme law. So that has been annexed by them.
We had disposed of some matters. Did we not? Are there not some matters which were disposed of under?
I think that was different. That was suggested.
Okay. Place number?
Their claim was rejected by page 35. And
No.
Clause is at page 33.
33.
Clause 5.
Yes. What does it say?
The exemption contained in this notification shall apply only to the following kind of units, namely a new industry unit which commences commercial production on or after 1st day of April 2007, but not later than 31st March of 2017. B. Industrial units existing before 1st day of April 2007, but which have undertaken substantial expansion by way of increase at not less than 25% in value of fixed capital investment in plant and machinery for the purpose of expansion of capacity modernization and diversification and have commenced commercial production from such expansion.
Where is the order rejecting their claim?
Page 35 and 30, there are two orders. One is at page 35 and another is at page 42. Let me come to page 35.
Yes. 35.
Please refer to your letter dated so and so, dated C3/2012 on the above subject on scrutiny of the office record, it is observed that you are engaged in manufacturing of accessible goods, namely cement, clinker, ordinary Portland cement and Portland modular cement, falling under surplus so respectively, and have been availing exemption as per new unit in terms of notification 20 of 2007, dated 25/4/2007, as amended, and availing refund of the excise paid duty through PLA in respect of the above final production with effect from 1/4/2008 in term of said notification. Para 5 of the notification as reproduced, I have already placed before your lordship. Let's say we turn to next page. From the above, it can be concluded that for availing exemption under notification 27 EC dated 25/4/2007, you come under clause para 5A of the above mentioned notification as new industry unit having commenced commercial production from 1st of April 2008. Therefore, in spite of having undertaken substantial expansion, which increased your production capacity from existing 600 TPT to 11,000 TPT with effect from 1/2/2012, you remain eligible to get benefit of exemption in term of notification 20/2007 as amended with effect from 1/4/2008, only for a period not exceeding 10 years from said period. In view of the above, your request for granting eligible certificate for exemption, excise duty on substantial expansion stand also. Thank page 42. Data dated 24/3/2017. Exemption of excise duty on substantial expansion. Please refer to your letter number so dated so on the above subject, wherein it has been requested to allow excise duty exemption in your unit with effect from 1/2/2012 in term of para 5B of notification number so as amended on the ground that the unit had undergone substantial expansion by way of increase by not less than 25% in the value of fixed capital investment, plant and machinery as required under their notification. It is not record that on application in this regard has already been submitted by you to the Deputy Commissioner of Central Excise Guwahati Division on 6/2012, and your claim of exemption as an existing unit was denied on the ground that your unit was already availing excise duty exemption with effect from 1/4/2008 as a new unit in term of para 5A of the said notification. In view of the above, it is reiterated that the unit being a new industry unit and falling under para 5A of the said notification is entitled to get benefit of exemption for a
They have
period.
already completed 10 years.
Yes, no, that is different, but they are claiming that they are existing in it. But as per our record, it is when they started their commercial production from 1st of April 2008. So they fall under 5A, not 5B.
I have a small plea, Your Lordship. Kindly the matter may be taken up on Tuesday, Your Lordship.
Five A of which clause?
That Lordship, page 33. Lord. This is a
Notwithstanding in para 3.
Lordship notification number 20 of 2007.
Yes.
The exemption by para 5. The exemption contained in this notification shall apply only to the following kind of units.
All right, right.
They fall under A, not under B. As per our
Tuesday,
Lordship.
I had in part. This
But-
one, Tuesday.
Published.